Yeah, please, Your Lordship. Lordship, with the consent of others, and I beg to mention item number 26 to 28, my lord. Lordship, in this case, my lord, 26 is infectious method, my lord. And other two, I pay for short adjournment, my lord. Other two, 27 and 28, my lord, I pay for some short adjournment, my lord. 26 is infectious.
Who are you?
I'm the petitioner, my lord.
You are the petitioner in all the matters.
Lordship, item number 26 and 27, my lord. And 28, I have taken consent. 20 in respect of 28, I have taken consent of the petitioner side.
Let the matter reach. Let the matter reach. Yes, Mr. Goswami.
May I please? May I have your lordship leave to mention item 45? My lord, this is your lordship. Remember the 2 weeks back that Oil
yes.
India matter came.
This
This is one more union and another set of contract laborers. So your lordship directed us to produce certain documents. So it will be almost on the same line.
When did I fix the earlier matter?
That 5th of March. Your lordship can
We
fix it on 5th of March. That's all.
Mr. P.K. Goswami, the learned senior counsel, appearing on behalf of the petitioner, admits that the instant writ petition is connected with an instant writ petition. The dispute involved in the instant writ petition is connected to writ petition number
8150/17.
8150/2017, which is fixed on 5th of March 2024. To list the matter along with the said writ petition.
No, this is 2020 matter.
Yes.
And allegation against them now is that they are trying to break the union by taking away the individual. So
We'll have it on
they
fifth.
should take into consideration.
We'll have it on fifth because I have asked somebody to produce some documents,
Yes.
if I remember.
Your lordship has given us time till 29th to file the petition. We will file. Obliged.
Right, Mr. Lordships. I beg to item number 40, my lord. During pendency, my lord, the respondent has passed an input order, my lord. So already passed a compliant order, my lord. So
Mr.
we have to challenge the state
learned
order.
counsel appearing on behalf of the petitioner submits that the order dated.
My lord.
What is the date of which order? Only mention. Let the matter reach. Only.
May it please the Lordship. Lordship, I beg to mention item number 31, Lordship. Lordship, senior counsel Dr. Ashok Shroff has been engaged for respondent number 1, 2, and 3. Lordship may not like to take a comment.
Okay. Item number 31, list the matter before any other court.
Obliged.
May please your lordship.
Not
And for item number 16.
Huh?
Item number 16.
Yes.
The petitioner might want to not press this case, madam.
Yes, what is your name?
M. Islam.
Mr. M.S. Islam, the learned counsel appearing on behalf of the petitioner submits that the petitioner does not want to press the instant writ petition for which the instant writ petition stands closed on withdrawal in time order if any standing.
May I please.
Really oblige your lordship.
Well, item 1 of today's list, my lord, the deputy commissioner has filed an affidavit yesterday. If I may please be permitted to bring the paper.
May I please, Lordship? Lordship, daily list of item 24, Lordship. Kindly granted 1 week time, Lordship. Today we are going to file the affidavit in reply, Lordship. Item 24.
Mrs. R. Wrongmate,
Yes, Lordship.
the learned counsel appearing on behalf of the petitioner submits that the affidavit in reply is in the process of being filed during the course of the day. Accordingly, it is the matter on 23rd of February 2024.
Must oblige, Lordship.
We should consent on the petition between item number 44. We're going to be taken on the first week of March, my lord.
Right.
But in the meantime, I'll get the instruction. That
Oh,
I
these matters.
instruction and I'm not got the
Very good, very
instruction
good.
by
Anyway, these matters stands alone is very good.
first week of March.
Very complicated. 44.
This is not complicated, man.
No. Your, these fancy weather, L pattern, fancy weather, all these things are very.
MJ Bora is involved, my lord. MJ Bora is involved.
Yeah, and without bringing MJ Borua into the scene, it's very difficult.
That is a different case, man.
Yes, when do you want it?
Let it be on first week of March, my lord. Any
Yeah.
day.
I won't be here from first week, so better off let it be in the last week of February. I'm not
Got
here. Yes. Place the matter again on 28 to 2024
Got it.
at the request of the learned counsel for the GM.
Got it. Okay.
May you please, your lordship?
28. Yeah.
Lordship, item number 34, in this matter, we have to, we are supposed to file our affidavit in reply, but the petitioner met with a sudden accident due to which it was not done, could not happen. Therefore, matter may be adjourned for 3 weeks.
The request of the learned counsel for the petitioner, matter stands adjourned to be listed after 4 weeks. In the meantime, the petitioner would be at liberty to file the reply.
Master.
May I please, your lordship?
Can you call Mr. P. Sharma, that fishery department counselor, anybody can call him. And Mr. B.J. Talukdar also.
May I please, your lordship? My lord, item number 6, my lord. May I pray for an adjournment because I am not feeling well today, my lord. Maybe after, my lord, last week of February, my lord, if lordship's convenience.
This matter earlier was adjourned,
Not an adjourned, my lord.
the 2017 matter.
Lordship.
You are not feeling well.
Yes, my lord.
Don't worry, we'll take it as the first item. Let's see. Item number 16. Madam, I need a copy of that record,
Reason
what you call reasons.
Only photocopy, or
Only the reasons.
only the
Reasons. Because without that, it is very difficult. Because they have an allegation out there that there is no reasons
Yes,
reported. So we need to just mention it.
yes, ma'am.
So just give me a photocopy of it. I don't
Photocopy of the
require.
reason.
And put it in a seal cover and give it to me.
Yes, ma'am.
Item number 7.
Yours is
I am 6, my lord. My matter is 6, my lord.
6. Have we got the updated status report?
Lordship.
Yes.
This is the
What is this case about?
My lord, here, my lord, the petitioners, my lord, the petitioner number 1, my lord, who is owner of a vehicle, my lord, and my lord, petitioner number 2, my lord, he is the driver of this, my lord, Bolero pickup vehicle, my lord. So when, my lord, this, my lord, was flying, my lord, the car, my lord, made with an accident. My lord.
So here you are challenging some validity of a transport license.
In fact, not the validity. In fact, my lord, the one report, my lord, sent by the, my lord, district.
Show me that.
That is, your lordship will kindly come to page 39, my lord.
Yes. What is this?
That is, my lord, the validity has been shown, my lord, as 17/11/2013. That is at, my lord, serial 5, my lord.
DL verification.
Yes, my lord. In
And-
fact, my lord, this license was duly renewed, my lord, and that was, my lord, not recorded in there, my lord.
When was it renewed?
Renewed at, your lordship will kindly, I have annexed my, my lord, driving license, my lord. Your lordship will kindly come to page 18, my lord. That is renewed on, my lord, this is with validity, my lord, 28/8/2017. But in the, my lord, report, my lord, that has been shown as, my lord, 2013, my
So
lord.
this is the only challenge.
Yes, my lord.
Where is the transport department?
My lord, I'm appearing on behalf of.
Yes, what is your stand?
My lord, my lord, may peruse the order of the honorable court dated 31/8/22, my lord. Some instructions were sought from the standing council, my lord. I may read.
No. What is
My
your
lord,
ins- Why have you done this?
my lord, the stand is that this is a fake document that has been produced,
This is a fake document.
my lord, which is why the CID inquiry was, the court had directed the CID inquiry,
This is a fake document.
my lord.
You have mentioned it.
My lord, it's in the order, my lord. It's in the order of the honorable court, my lord. 31/8/2022.
In fact, my lord, this was the, my lord,
My lord, may peruse paragraph number 4.
stand, my lord, of the department. That the, my lord, driver was authorized to, my lord, drive the vehicle without PSV, my lord.
Now, what does the CID do?
My lord, documents are seized, my lord, and it has sent for FSL and 3-4 months is required for completion of the investigation.
What FSL?
My lord, because these documents, because there are countersigned by the DTO is also there, my lord, in that documents, my lord. Lordship will find just, my lord,
In fact, my lord, what has happened here, my lord? He was owning this, my lord, driving license with the, my lord, authority. That is, my lord, phase 18, my lord, that is motorcycle, LMB, MGB, and HGV, my lord. So when that was renewed, my lord, this PSV option has been, my lord,
What is PSB?
that is, my lord, you'll also will kindly come to page 18, my lord.
What is PSB?
PSV, that is my public service vehicle. So that was wrongly inserted in my lord, renewed license, my lord.
Ah.
So that was their case that in fact, my lord, PSB, since I am not, my lord, I am not getting license of PSB. So how, my lord, this license is, my lord, having PSB authority, is, my lord, my lord.
When
Can
did
be-
you get this license on page 18?
My lord,
When did you get that license?
that is in 2008, my lord. And my lord, after my lord,
Then is it your case that the PSB was wrongly inserted?
yes, my lord.
Did you complain it that you have wrongly inserted PSB?
That is, my lord, my affidavit is to that effect, my lord.
Have you complained to the authorities?
Yes,
that
yes,
they're
my
wrong?
lord. Yes.
When?
That is, my lord, at a very, my lord, after I have seen this, my lord, wrong insertion, my lord. In fact, in
When did you inform?
immediately, my lord, after this,
Okay,
my
you have informed. You must have informed on the basis of a communication.
In fact, my lord, there was some verbal
So
communication.
how
was
can
there.
there be a verbal communication?
Because, my lord, at that time, my lord, there was no such, my lord, I was directed to, my lord,
No,
by
you should
way
have
of-
filed an application to that effect that you have
Yes.
wrongly incorporated. Why haven't you done that?
In fact, that was, my lord,
So that means you have taken the benefit of this license.
no, in
Were
fact,
you driving a PSV?
like, I was not driving, my lord.
What were you driving?
I was, my lord, a Bolero pickup, that is, my lord, a goods vehicle, my lord. I never, my lord, drive
Bolero
any-
pickup is a public transport vehicle.
No, man, it's goods vehicle, man.
And what is PSV?
PSB is for public service vehicle.
So what is
But it is public carrying, my lord, public carrying vehicle.
and Bolero is not.
That is normal. That is only
Bolero
goods.
pickup van is not.
Not, man.
It's private.
Yes, yes. And it is, my lord, only goods for the purpose of, my lord, carrying goods.
Okay. Now what has happened thereafter?
So, my lord, that was, my lord, inadvertently, that was inserted in my, driving license, my lord. When I just saw this, my lord, I immediately, approached the authority for just, to issue with the, the exact, the authority, what I was earlier, having the license, my lord. So, in, by that time, district transport officer who got transferred, my lord, and subsequently, my lord, they were reluctant to issue me with the, my original authority.
Your earlier license became invalid when? Validity was till what time?
In 2013, my earlier, license.
1911, 2013.
Yes, my lord. Your lordship.
And the fresh license was issued on
That is-
29/8/2014.
Yes, my lord.
What were you doing all this while?
My lord.
Why did it take such a long time to get the new license?
No, my lord. In 2013, my earlier, my lord.
Understood.
Yes,
On-
my
you are a driver.
lordship.
Your occupation is a driver.
Yes, my lord.
What were you doing for these 8-9 months?
No, in fact, my lord, that is,
It is clear.
Yes,
Your
my lord.
license you was there till 17/11/2013.
Yes, my
And
lord.
you got this license on 29/8/2014.
Yes, my lord.
Meaning thereby for almost 8-9 months you had no license.
My lord, in fact, my lord,
When did you apply for this license?
That is, my license expired on, my lord, 17/11/2013.
I
earlier one.
understand that. When did
Yes.
you apply for that license?
Immediately after that, my lord.
After expiry.
Yes, my lord.
When did you apply?
I applied in the year, my lord, 2014 because 18/11 earlier was expired, my lord. So in the year of 2014, I applied, my lord. So because of some procedures, that is the official, my lord, purpose for that, my lord, I had to wait, my lord. And accordingly, my lord, this is, my lord, this was issued to me, and immediately after see this, my lord, this PSB option, my lord. So I approached the authority, my lord. So they, in fact, my lord, are reluctant to issue immediately that, my lord. And my lord, meanwhile, my lord, the DTO concerned, he was, my lord, transferred from
These
that office.
professional licenses are given for only 3 years.
3 years, my lord.
So earlier, prior to that, what was the license?
For 3 years. That is the same, my lord. That is without PSB.
Hmm.
My earlier, my lord, all the earlier licenses were, my lord, for, my lord, this motorcycle, LMB, MGB, and AGB, not PSB.
Where is your earlier license?
Earlier license, my lord, I have not annexed it, my lord.
Then why?
But I have, my lord, mentioned in my paragraph 8, my lord.
Mentioning would
Yes,
not
madam.
do. You are asking this court to enter into an arena of disputed questions of fact where the respondent authorities, we are to believe that the respondent authorities were right.
Lordship.
Then
Now, in fact, my
why
lord,
should we enter into
I
all
can
these things?
produce my earlier license, my lord, I can produce, my lord.
They are categorically mentioning out here that there
Yes.
was no license applied by you thereafter.
My lord, my earlier licenses are there with me, my lord.
Hmm.
Earlier licenses are with me, my lord.
How can this court keep on deciding all these things? Asking the police. The
In which-
police report, why is it taking such a long time? The order was passed in the year 2022.
Lordship.
Huh?
Lordship.
It's a simple case. You are to find out as to whether that particular person have issued it, whether he had applied or not.
No, yes.
Then they say the DTO officials say that there was no application. Isn't that?
Yes.
So there was therefore this license is fake. And what else is required?
Lordship, because they have gone, my lord, detailed, my lord, that investigation, my lord, that because it is suspected that PSB has been inserted later on.
Forget about the PSB. The question is whether the license was issued.
Lordship.
Why do you need 3 months for that?
Lordship.
I have, my lord,
Or does the CID has so much of time, has no other work?
Lordship, they have, my
We
lord.
know that Assam has become a zero, what you call crime rate. So
Lordship.
for that, the CID has no work and doing all these things
My lord.
for months to on.
Yes, my lord, because all the, my lord, signatures and all have been sent for FSL, my
Why
lord.
is it required?
Lordship.
Simple question is as to whether the DTO office has issued or not.
Not, Lordship.
Have they found out that there was a signature out there? Let us see the report. What do they say? Why the signatures are there? Visited the place of occurrence. Examined so and so. issued notice, seized documents, driving license of so and so.
That's right.
On being produced by the dealing so and so. Collected written details report from the DTO. Collected written report from the relating to some requirement in connection. Sent a WT message. My goodness.
Lordship,
The only thing is required whether there is a file
File.
maintained out there or not.
my lord, whether that applied or not, if it is
Hmm.
not applied or if it is not issued by the
Simple
authority,
thing.
lordship.
They say that there is nothing. The records will clearly show as to whether they have made an application and whether there is a signature of the DTO and all these officials.
Lordship,
And these are nowadays, this happened when? 2014. And in the year 2014, these are all smart cards.
My lord,
These are smart licenses.
Yes.
Obviously, these are smart licenses, yes or no?
is it not?
This is not a smart license.
This is not, my lord.
Okay, this is not a smart license.
No, the endorsement book is annexed in the affidavit.
And when was the petition filed? In
That is-
2017.
Lordship.
And what was the occasion of filing this in 2017?
My case, my lord.
Why?
In
Because
fact, my
of the
lord,
insurance.
Yes, because it was pending before the insurance, my lord. Then before the insurance authority, my
Yes, yes, just 1 minute. Mr. Sharma and Mr. BJ Talukdar,
Yes, sir.
yesterday after thinking, I've dictated the judgment, but the one which I was proposing of directing you to go for a fresh settlement, I am not passing that order. I am directing you to, I am setting aside that earlier settlement, observing whatever is required, that there was no requirement of all these things, and to directing you to take a decision within a period of 15 days.
Right.
Because that's why I'm asking you, because otherwise it becomes too complicated. With the impending general elections, it will become very complicated. And this settlement would never happen. So within 15 days, you have to take a decision on the, after setting aside, I've held out there that there was the Bakija certificate was enough. The question of overdue, there being no mention out there in the NIT, anything to that effect. The secondly, as regards the certificate of Mr. M. Dotta's matter, I said that the certificate was in due compliance to that, so it could not have been rejected on that basis because it is the normal certificate which all certain charter accountants give. They can never vouch for the accuracy of the transactions. Neither they can vouch because unless they do an audit. So when they certificate, and it is only what was required was only a verification. You don't require the certificate. If you see the other tenderers, they have only given under the seal and signature of the authority, which was duly given now. So under such that also rejection on that basis for that tenderer is bad. However, Mr. J. Payan's thing is he did not submit that document at that. So under such he is not an eligible tender. And therefore directing you to reconsider within 15 days. That is a easier mode of doing it. Otherwise, it becomes very complicated. So I'm not asking for going for fresh. Now it will be your decision to take a call of what to do.
During the minor interim period, has the lordship.
15 days.
15 days.
You have to complete. And secondly, this court is going to put a note. There is no stay to the settlement proceedings. No stay.
No stay, no?
There is no stay. So under such circumstances, how are you allowing him to run on this for last 4 years, taking on daily basis where he had quoted 2 crores 91 lakhs? You should have taken for these period this. After all, it's a question of revenue of the state.
Yes.
One has to take note of these aspects of the matter. So I'm putting an observation to that. But therefore, I'm directing this within 15 days you to come. Do whatever you like. I'm not directing because for me to direct for going for fresh settlement is also, I think, outside the jurisdiction under 226. I'm not granting that they should be granted a settlement. You take a decision. You'll get the order today in the evening. It has become a bit long, but yesterday it was really late in the night.
Well, at page 34, my lord, I have annexed my lord, money receipt, my lord, where my lord, my lord, driving license was renewed, my lord. That is through RTI, my lord, I received this, my lord, money received, my lord. That is page 34 is the letter by the, my lord, authority, DTO, to the petitioner, my lord, page 34. And my lord, your lordship will kindly come to page 35 is the money received, my lord. My renewal, my lord, of the driving license, my lord. Dated, my lord, 29/08/2014. This is the date of renewal, my lord. And my lord, received from the sum of so and so. And
Let us do one thing.
yes,
This court have duly taken note of the report which have been placed in the interim in the updated investigative report of the CID dated 30. This is of the year 2023.
Lordship,
Madam, this is 1 year old.
sorry, my lord, extremely sorry, my lord, extremely sorry, my lord.
You call the CID inspector.
I have found it here, my lord.
The record reveals that this court on various occasions have directed the respondent authorities to produce the respondent superintendent of police. Have directed the inspector of police CID to give an updated status of the investigation so carried out in pursuance to the order dated 31/8/2022. The last of such directions were issued on 7/2/2023. It surprises this court that when this court had asked Mrs. Yudas, the additional senior government advocate, as regards the status of the investigation, the report dated 31/2023 was placed.
Lordship, I'm extremely sorry, my lord. I thought it is, but somehow 24, 31, 20.
Under such circumstances, it seems that as the said report have not been placed, this court fixes the matter again on 12th of February 2024.
can it be, my lord, after 26? My lord?
Absolutely no.
Lordship.
You appear or don't appear, we are not concerned. It is a question of investigation.
Lordship,
On 12th of February 2024, on which date the CID, the investigating officer in the CID shall produce the updated status report without fail.
Lordship.
Look.
Lordship, I'm extremely sorry.
We will consider later on. Let us first see the report.
Lordship, oblige me.
This is not the, luckily I saw out there.
Lordship, I also, my lord, 31, 24, my lord. I'm sorry, I'm sorry.
Already yesterday, the copy of one affidavit has been supplied to me, my lord. Probably I should file in the reply, my lord, of 2 pages or 3 pages, my lord. They are saying that it has not been applied, and lordship already aware that already I have applied for
What applied?
settlement, my lord. That documents I have, my lord. So 1
What
week.
affidavit to me? Your land is on the back side.
Yes.
That's the case, no?
Yes.
And he's in the front side.
Yes.
So you want a settlement in respect to that land.
Yes. Yes.
That is why you are approached this court. This court have asked them as to whether what is your instruction, what is your stand?
That they are not in possession of the land.
Ah, they are not in possession.
Since
They
it was
want a
blocked.
query by whether the land measuring 2 × 10 lakhs is allotted after the receipt of the sum was who allotted in pursuant to the lease is to be mentioned. The governor was pleased to recommend for settlement of the Sarkari land and can for state purpose to involve which keep at of purpose of opponent which the land being a continuity and the between the petitioner and the without the never applied for the settlement. Yes.
And
Here
that,
it says that you have not applied.
no,
How can you get a settlement?
yes, that is my letter. Since I have the documents on that day also, I have placed before lordship. These are the documents
What document?
that I have applied for.
When?
It's 21, my lord.
Huh?
It was 21,
2021.
21.
You applied.
Yeah, yes.
You applied in the year 2021. Then
21.
what remains of this petition in of 2017?
No, since my
And
lord,
if you have applied, you must have applied in 2021 as per the Vasundhara scheme. Vasundhara scheme category, the moment you apply, they give you 300 days. They will intimate you as to whether your application has been allowed or not. Have you seen it out there in the records,
is-
whether it
it
has
is-
been given or not?
it is not on Vasundhara, my lord. It is in regular process. It was applied.
Then what happened?
Till that,
So you have applied. If it doesn't happen, it is a fresh cause of action. What remains in this petition? When they say that you are not in occupation of this land.
no, my lord, since the front part of the land is already been blocked by this respondent. That is why, my lord, since 1980, my lord, it has been already blocked. I could not say my thatch house was there, tin house was there, and that at the time of purchasing the land, and
Now what do you
my
want?
father was the colonel. My lord, all along I was.
And whatever may be, these are
Lordship.
disputed questions of fact, go
Lordship.
before the civil court.
Lordship.
But the question is, what do you want out here?
Yeah, here, my lord, only.
What is your relief sought for?
Yes, only, my lord, here as per this report, RTI
For
report, my lord,
settlement of the land in favor of 1 bigha of land.
1 big of land, and that.
Now you have forgone it by asking for less.
Yes, my
So
lord,
this application.
since,
Settle the rest part of the land to poor and landless lady petitioners on her entitlement as per year. When did you apply? That was applied, you don't know. Set aside and quash the impugned order of settlement in favor of the respondent. You are not now pressing this.
Lordship.
Are you pressing the settlement order against him? Challenging?
My lord, since, my lord, that
And if you want to challenge it, you have to go to the Board of Revenue.
No, I'm not on that, my lord. Only
So
rest of-
now if you want a
rest of the-
settlement, then the settlement has to be made as per as per this. Now where you have not brought on, and if it is so, it is a fresh cause of action. What remains in this proceeding?
I
Because
know.
if I record out here, your case is very damaging for the affidavit. The affidavit categorically says that you are not in occupation.
No.
You have not applied as per the 89 or even as per the 2019. What mean?
Now, my lord, only that part, my lord, I'll bring.
What
to
is
the-
your application number?
That is 13562/21 and 13561.
How many why there are two applications?
Two application, one son and daughter, son and mother, my lord.
Son and mother, asking for 1 katha 10 lachas each.
1 kata 5 liters, 1 kata 5 liters.
Each.
Because now out of 1 bigha, my lord, since respondent number 5, this private respondents have occupied the front side land around half bighas. Then half bighas has been remain in the last part, my lord, which has already been blocked by the gate, my lord. So only in view of this RTI, my lord, where I have got the report of the additional secretary, which was written to the additional chief secretary, saying that since this dispute is there, if the this main gate is open, then the dispute will be resolved. That part was remain, my lord. That already I have brought the fact in my reply itself, my lord. That it has been said on the basis of this the RTI this report, the lordship has come to the conclusion that if
But if you are not in possession, the possession you
no,
can't
my
be
lord,
there.
since
You can't be there in possession.
my lord, the fact is remain, my lord, since the land is itself blocked by the gate, my lord. The question of possession doesn't arise, my lord, because already it has been blocked. The front side is blocked.
Under such scenario, why haven't you filed a civil suit?
My lord, the civil suit, my lord, my lord, it goes on, my lord, this filing
So
this
you
way,
come
that
before
way,
this court.
my lord. That is the problem. Now only resolving is the part, my lord, that since lordship has gone through the reply, my reply, my lord, I have categorically enclosed, my lord. The reply, it was filed on.
No, Mr. Chetty, what remains in your petition now? You are asking for settlement of 1 bigha, which is not there. You are asking for setting aside his settlement, that is not there. You are asking that a settlement should be made in favor of the poor lady, which is there. You have done it again and have applied in the year 2021, which is a separate cause of action. What remains in the
Only,
instant
my lord, since I'm not going to the dispute, my lord, where the respondents are residing since long, my lord. I'm not on that, my lord. I'm leaving all these things, my lord. Only my simple and the shortest prayer before lordship. That since as per the report, my lord, I'm just reading out, my lord. The additional chief secretary, it was written to the additional chief secretary by the secretary, my lord. The matter, just I'm reading for lordships. That is 29/9/2014 report, my lord. This matter has been pending for a pretty long time. Considering the complexity of the matter, I plan a site visit to the ground situation on 26/3/14. I visited to the site being accompanied by Circle Officer Dispur C. Nath. Both the parties, which Partijit Borua, settlement order by so has been issued. Complainant MS Nilakshi Datta Saikia were present. The 2 kathas 10 lesser plot of land settled by 30C is a part of a bigger plot of 1 bigger approximate bounded by a common wall and having a single entrance iron gate. As stated by the complainant, Ms. Nilakshi, the 1 bigger of annual patta status land was handed over possession to her mother, Mrs. Anjali Datta, wife of Major S.K. Datta, by the AP annual patta holder, copy of the Sancho. Land revenue payment by S.K. Datta at Sancho. We paid the land revenue also. However, subsequently pursuant to DC Kamrup Metro proposal by R1 129C, a portion of the said land is 2 katha 10 lesser was ordered settlement in favor of the Partijit Borua and another for trade purpose.
Now, who is Nilakshi Datta?
Nilakshi Datta, the petitioner number 1, the daughter.
Now, the daughter has applied or the mother has applied?
Now, daughter has applied. Mother already now, pendency of this petition, my lord, she has already expired, my lord. Now,
that only prayer which was there to give it to the old widow is also gone.
And the daughter is there, my lord. They are all, my lord, this landless person, my lord, it is founded, my lord, during the site plan, site visit, the land portion settlement in favor of Mr. Partijit is at Tron portion. And the passage to the remaining portion is only through the to be settled portion of the land. This has been creating difficulty as regard entrance to the remaining portion of the land. As regard the remaining portion of the land, leasing the settled portion of the 1 bigger plot khas sarkari status, Nilakshi claimed it to be under the possession. On the other hand, Mrs. Partijit claims it to be possession of her sister-in-law.
Yes, Mr. Mohanta, what do you propose to do if he is granted the possession?
My lord, now he says that, my lord, I blocked the gate, my lord, that, my lord, district administration, if it is true, my lord, that can be cleared because his plan is still there, my lord. I don't know it is his Sarkari land, my lord, but his case may be considered on that land, my lord, because the out of 1 bigha.
What happens to the blockage?
Blockage, my lord, from the report, I have seen that there is a report, my lord. Yes, if it is, then it will be cleared, my lord. I don't know, my lord, whether it is really block or not, my lord. If it is a block,
you are instructed by whom?
My lord.
Who is instructing you in this matter? Him. You have no objection as regards the backside.
My lord.
Pursuant to the orders passed by this court, an affidavit, additional affidavit in opposition has been filed by the District Commissioner, Kamrup, stating inter alia that the petitioner neither applied as per the settlement rules either under the land policy of 1989 or under the land policy of 2019. Full stop. However, Mr. B. Chetri, appearing on behalf of the petitioner, drawing the attention to the affidavit in reply filed on 24/1/2023, submitted that in the year 2000 on 26/11/2021, two applications were filed seeking settlement of the land at measuring 1 katha 5 lechas each. The receipt numbers of the said application are 13562 and 13561 dated 26/11/2021. This court also had taken note of the report being the communication issued by the additional chief secretary, wherein it has been mentioned that the land wherein the petitioners are seeking settlement is a land, the entrance to the said land has been blocked by the private respondent. This court had put a specific query upon Mr. T.J. Mohanta, the learned senior counsel, as to whether the said private respondent, learned senior counsel appearing for the private respondent, as to whether the private respondent would have any difficulties in giving a right to way to the petitioner if the land is granted, if any allotment of the land is granted to the petitioner. Mr. T.K. Mohanta, the learned senior counsel, submits that he will obtain instructions in that regard. List the matter again on 4th of March 2024. This court further directs the district administration of the district commissioner Kamrup Petro to apprise this court as to the applications so filed by whom? Hello? Whom? Who has filed?
By Nilakshi Datta, petitioner number 2,
And
Rohit Saikia, her daughter, her son.
Nilakshi Datta is alive.
Yes.
And Rohit,
And her son, Rohit Saikia.
what is the age of Nilakshi Datta?
Nilakshi Datta, she is now 52 years.
And son?
Son about 25 years.
Filed by one Nilakshi Datta, whose application bears serial number?
Serial number Nilakshi Datta 13562/21.
2/21 dated 26/11/2021, and Sri Rohit Saikia bearing serial number 13561 dated 26/11/2021 on the next day. Full stop. Mr. B. Chetri shall provide a copy copies of the said application to Mrs. S. Sharma during the course of the day so that she is in a position to obtain the instructions.
Deeply.
Number two.
File delay.
Yes. What is your proposal? You have got the money?
No, Lordship, I have applied procedure.
We applied for it.
Lordship,
Huh?
Necessary documents have been submitted to the office of the DP. Once they process the
Lordship,
documents.
my lord, someone for a status report, but I have received it, my lord, Lordship may kindly peruse it.
So when do we expect further?
My lord, now immediately, my lord, this rupees 9,91,000 that will be released, my lord, to the PT. They are verifying, cross-verifying the bank details. So that is required, my lord, so that money doesn't flow to wrong hands. Then, my lord, with other, my lord, issues regarding acquisition at page number 2 of that status report. Proceedings in, my lord, there is a government plan. My lord, that is measuring, my lord, 72.31 hours. Quite a considerable area of land. Quite a considerable area of land. So they are working out on it, my lord. And I'm my
Yeah.
lord, their authorities are working on it, my lord, because this plot of land, it is not required to be, my lord, acquired nor requisition. But
But allotment has to be made.
no, allotment has to be made.
That's
That
a different-
is defined.
But
So
you are the owners of dark number 3524 and 3358.
3,358.
770-772, patta number 32. Lordship.
You have 770 also.
770-772 and KP patta number 32.
And you are, and what, 770 and 772.
Yes.
Here they are saying that 770 is the government dark.
No, Lordship.
As per report, Municipal kindly see, my lord, I am reading in my lord. From the an acquisition proposal was submitted by the circle officer dated 1/4.
Where is your document showing the dark number 770 is yours?
And if you do, you see.
You must be
Yeah,
having a
sir.
patta.
Yes, Lord.
Ah, this one is there. Kindly come to page 12. Page 12 of the repetition.
Page 12.
Annexure A, Lordship.
Yes. Yes, 770 is their land. How are you saying that?
770 is there land, my lord, as per annexure A, that is measuring 4 bigger 15 lesser.
Then
But
why
here-
you have made that is a huge chunk. 4 bigas 15 lesser is how much?
4 bigger 15 lesser, you convert it to hours.
415 liters into 1076 divided by
72.31 government.
Part of the insurance do not.
Maybe subsequently. for the same thing.
55.53 hours.
55.53
Out
hours.
of this 78, 55.53 belongs to them. What is this type of report you are submitting? 72.31 R, out of that 55.53 belongs to them.
Therefore, my lord, lordship,
So this report is wrong.
this report has been submitted by the circle officer dispute.
This is a delay, ploy of delay. This is a fraud being played on the basis of the acquisition proceedings and requisition proceedings.
Therefore, my lord,
So we have to therefore set aside this and hand over the possession within 4 months.
because GMC building is already there standing
Okay,
there.
demolish it. You want that building or don't want that building? Demolish it. Or give it to them. They will have their house, have a hotel. You can't construct. How are you constructing? By requisitioning a land, how can you construct?
Yeah. Otherwise,
You can't do this. And this is what the additional district commissioner is doing it, just delaying it.
my lord, what I pay, my lord. Lordship may be pleased to summon the circle officer with the original
Why
record.
should I summon? Is it my duty to summon?
No,
Is this the first, they have lights over dark number 770, which contains, and here you have put 770 as a government land.
So therefore, my lord,
Why should I summon?
no to claim.
The best option is 770, whichever their land, you demarcate and give it to them. That is the only thing which needs to be done. Why the circle officer is not demarcating as per the record of rights and find it out? Because the circle officer does not want to antagonize the medical authorities. He's suffering from health problems.
So, but here it is said, my lord, that the records are old, my lord. Now, as per report, my lord, dark number
What is
720.
his basis to say that 770 falls within them?
That's why, my lord. What is the basis, my lord? Let us know from the circle officer, my lord. Nothing can call him, my
That
lord.
is your lookout. Well, you want to know from the circle officer, you know, but from the documents out there, it clearly shows. See the order sheet of the LA case. 770. You see, schedule of land which you are requisitioning is 770 is there, 6 bighas, 3 kathas. This is an order of the collector in the year 1981. And the last 20, 30, 40 years, isn't this a case by which the requisition is, can't keep this land like this?
Let me also present this, because the circle officer has been directed to verify the records because of this reason. That how come minus 770 falls within government land? Let's me kindly see this. It is in the possession of GMCX.
This I have seen it. Earlier, somewhere you must have seen it.
If, my lord, before taking a final call, my lord, my humble submission would be, my lord, lordship may be pleased to, my lord, see the original records, my lord, and
Why should I see the records?
so because there is a
What is the
contradiction.
basis on which the circle officer or the additional deputy commissioner says that it is a government land 770?
Yes, so that's why, my lord.
When you have initiated proceedings for acquisition,
Yes.
this is an appropriation made by me, not the appropriation is not a correct or misappropriation by the government. I don't want to. It is not for me to make those type of inquiries. It is for you. This additional district commissioner, why has he written all these things as it to be a government land?
No, my lord, he is acting on the strength of the report from the circle officer.
So
because
what is the basis on which the circle officer is doing it?
Yes.
He is just, there's only one line. There's a report from the circle officer.
Yes.
What business does the circle officer to have to do? When it has been requisitioned, you have requisitioned in the year 1981, and now you, on one fine morning, you, when this court takes up the matter, that how can you keep the matter requisition for the last 40, 50 years? Now you are taking up the issue. Now you say that this is a common land.
Yes, otherwise, my lord, in the requisition order also, my lord, 770.
Yes, and that to 6 figures, which is the total 72.
Yes, no, my lord, yes, 770, it is core.
All right.
770 core. So might be,
No,
my lord.
see the area of land, 6 figures.
Six bigger,
Six
lordship.
big, right?
No, therefore that 6 figures, although out here it is in his Jamabandi shown as 4 figures, the 15 letters, 15 letters, which will be around 53 hours, 55 hours. But if you take 6 figures, it will be 72.31 hours.
Yes. The government could not have requisitioned its own land. Even if we assume that it is a government land.
One fine morning, the circle officer comes up, oh, how much amount? We can't pay so much of amount. Better make this a government act.
So therefore,
We are in control of all the land documents. We'll do whatever we feel like. Is this the thing which the circle officer is trying to do?
Lordship will call the circle officer with all the effort.
I am not going to call. You call the circle officer and explain. Take his explanation. This is not my business out here to call anybody.
No, my
I am only here to give the land back to the petitioner.
lord, that is-
Along with the building, if you have constructed at your own risk.
no, that is definitely there, my lord. But
And does this land fall out there in that big one, the
GMC.
hard thoracic, what is that?
No, not in the new
Cardiothoracic thing?
building.
Is
No,
that
lordship, the
person?
old building. Morgue area, morgue area was there.
area was there.
Very well.
That morgue building.
Building is not so good. You can give it. No problem.
Lordship may be pleased, my lord. to
Give
keep-
that building.
No, my lord, we will give that building.
You may have to do a lot of puja and all these things. That's a different thing. Because it has been a morgue for a long time. For using it for residential purpose.
Let the
Somebody else was residing.
therefore, my lord, let the evil spirits may not rise up, my lord. But at the end of the day, no, because I am also, my lord, confronted with these two, my lord, discrepancies in the, my lord, with petition as well as the report. So therefore, let us hear it from the circle officer. This is my.
You hear it from the circle
No,
officer.
my-
See from the documents. Well, is it for me to look into those documents? On
No,
what basis does he want to make it? I'm not going to do all this. The requisition order categorically shows it's an order of the collector,
yes,
showing that this order was, the land was,
yes,
on the basis thereof, you are also paying this 9 lakhs. You have already paid all this time. So you have duly acknowledged that 770 was a part of. Then what else do you mean?
no, my
And
lord,
now one fine day, the circle officer comes up and says, no, this is wrong.
no, my lord, my apprehension is that, my lord, if
We'll give some other land to them.
other land, my lord, there is scarcity of
How
land.
much land is there?
Lordship, in my writ petition, 2 bigha 10 katha, lordship.
No,
2 bigha 10 lesser.
you give
lordship.
that settlement of that land, na? The Babujari, that land. Yesterday you got that judgment. Give that. Consider that. Good land. Give it to them.
We have
They
to-
will be happy. You want to just near to the jail. Good luck.
That will be more better.
Give it to them.
Atma will have-
my lord, the difficult.
These are all prime locations. Their land is also in the prime location.
No, at the end of the day, lordship will be interfering with this prolonged requisition.
Absolutely. This
Yes.
is not
No.
only that.
Mm.
I am directing for handing over the possession. Because this, you can't keep it like this. at the end of the day or whatever may be, this is on the basis of these dark numbers which are there in the requisition.
Yes.
And that judgment is there. Yesterday I got hold
Yes,
of
yes,
a
yes,
judgment.
yes. I have got it. MD,
And lordship
is
is
the paragraph 6 is pinching. It is pinching on us.
So that judgment,
There is no way of escape.
Uh,
I have gone through it, madam.
that judgment is the
No, no,
judgment on which I am going to do.
Lordship will be pleased to dispose of the application, no difficulty, madam. But 7 except this 770, which they now say. But my apprehension is that, my lord, if on field there is any discrepancy with regard to 770, whether it is government done. Let us.
Can it be a government act?
No, how can it be a government that?
They must have thought it because keeping it under requisition for 40 years, they made it government. This is what you must have done.
No, so therefore,
During the resettlement operation, you must have done all these things.
yes. Now, this.
moreover, lordship, they have
Because,
filed
because
affidavit, lordship.
Mr. Warpujari, you need, I'm not calling the circle officer because what is required, the exercise is required is for not this court to do, because what is required, you have to first locate where 770 was there in the original map. And then from that original map, you have to trace it out with the new map.
Absolutely.
And then find out in the resettlement operation, which is that particular area where 770 was located.
Yes.
And you have, by way of requisition, have clearly identified
Yes,
that
yes, yes.
particular 770
770.
and to be a more area.
Yes.
Now he wants to make it somewhere else. So you come up with a better instructions on 15th of February. List the matter on 15th of February for further
I will, yes, I will.
hearing.
Because this instruction, my lord, to be fair.
I'm not considering
No, no,
this type of
my
instruction.
submission, because I received it
Better
late.
instructions on
Late
this.
evening, so I could not cross verify with the revenue officer.
What is there? I
Yes,
have
yes,
told
yes,
you
I got it, I
how
got it.
how you are going to find out
Yes.
770.
Yes, yes. I take it, my lord, I take.
Obliged.
May I please, Lordship? Lordship, peruse the last order. Last order is the 3/1/2024, Lordship, whereby the respondent was directed to obtain instruction in this regard.
Yes.
My lord, can I be accommodated with 2 weeks time only?
How much?
2 weeks. I requested my learned friend to give a chart of those persons whose cases could not be settled yet.
Give it, because what is this business of approx?
Lordship, what happened?
There
Lordship?
cannot be 757,307 approx. You are going on the question of approx
No,
on
Lordship,
the
I have given,
on the paisa.
no, Lordship, I have given,
It cannot be, because when you are identifying the last digit as 7, it can't be an approx.
no, Lordship, I have given actual amount, Lordship, but Honorable Court has recorded as approx, Lordship. 141 lakhs 6,989.
That is
And-
not being done.
and-
It has been mentioned as 41 lakhs and 757,307 approx.
And 7,58,307.
Okay. Mr. K. Kolta, appearing on behalf of the Oil India Limited, has submitted that the dues now, which the petitioner is entitled to, is rupees 7,58,307 on account of GPA, and an amount of rupees
41,06,989.
985.
989.
989 on account of marine inland insurance. Insurance, huh?
Yes, sir.
Mr. S. Dotto, the learned senior counsel, appearing on behalf of the respondent insurance company, submitted that a direction be issued to the petitioner to provide the details as to who are the persons who have not received.
Yes.
Not received.
Yes.
So that
In fact, my lord, whose case has not been settled.
to provide the
Lordship, I am giving.
to provide the details as to the persons whose cases have been settled and whose cases have not been settled, so that he can take a proper instructions in that regard.
Lordship, I have handed over.
Mr. K. Quinter, the learned counsel appearing on behalf of the Oil India, submitted that he will do so during the course of the day. To accordingly list the matter on 11th of March 2024, on which date the said instructions be obtained. The instructions be obtained by Mr. S. Doctor as to what further steps the insurance company is going to take in that in respect to the unsettled amounts.
Much of it.
Yeah, Mr. Lord. My lord, in this case, my lord, the land is allotted to me for setting up a printing press. For setting up a printing press, my lord.
Okay, then.
Accordingly, my lord, the
That matter type.
yes,
They disposed of.
this was
I-
I was
I-
disposed of.
interim was vacated.
Taking into account the order dated IA, passed in IA, this board directs the registry to list the petition for admission after the entry. Yes, what is this IA business? Taking into account the human insuring. Oh, this is for final disposal.
Yes.
Yes, now tell me.
So, my lord, I have taken over the position. I have constructed the boundary wall. Some lakhs of rupees I have spent. Thereafter, my lord, for electricity connection, my lord, I applied for no objection certificate before the respondent. And thereafter, my lord, I received the information that before 1 year back, my lord, the per square feet was scheduled as 0.35 paisa per square feet. The rent was fixed in that way. However, they revised this rent.
You have taken a
Possession, my lord,
of what?
for setting up a land, my lord, 7056 square feet of land
From
from the respondent number 5 from ASIDC.
okay, then ASIDC is where?
My lord, respondent number 6. 4 and
Respond
6.
number 3.
4.
No, where is ASIDC?
ASIDC is 6, my lord.
ASIDC is not a party.
My lord,
6, my lord.
6, 6.
Where is 6? 6 is officer in charge ASIDC.
Assumption, yes, it is.
There's no AICDC as a party. Anyway, tell me, you have taken the land from ASIDC?
From no land from respondent number 5, the general manager, district industries and commerce center.
Huh?
I have entered within
Your
agreement.
petition is number what? 5881?
Yes, my lord. 581.
Okay. You see, number 1 is industries department, number 2 is director industries, number 3 is managing director ASIDC, AIDC. Number 4 is managing director ASIDC.
ASIDC.
Number 5 is general manager district industries and commerce center. How does the district industries and commerce center has any business in allotting the land to you?
Now, my lord, entered agreement with the Assam Small Industries Development Corporation. This is the
Yes.
lease deed. Here's the page 18. There is the lease deed.
Page?
18 is the lease deed.
Okay, then.
Accordingly, my lord, 7056 square feet of land. And I have taken over the possession. I have spent the constructed the boundary wall. Shed was constructed. About some lakhs of rupees I have spent, my lord. The rent was in the agreement, my lord. 35 per square feet rent.
This
was
is a deed of lease.
This is the deed of this page 18.
Jyoti Printing and
I am Jyoti Printing
ASIDC.
Industry.
Is earmarked for use in connection with the development of small scale products. and where the lessor has applied for a, whereas the lessor now therefore in consideration of demand, the lease length of years reserved, the lessor hereby demands the lessee for the purpose of constructing a shed building so and so on demand. Then for 10, lease will be valid for 10 years
Yes,
from
my
the date of execution of the lease. Then what happens? 10 years is gone.
And my lord, I have not started the business because they did not provide the electricity. And also, my lord, the rent was fixed of rupees 35 paisa per square feet.
Ah.
And my lord, the rent was already revised by them, the respondent. So I applied for a rectified bill for monthly rate in the revised rate. Accordingly, my lord, I submitted the petition, submitted representation. This is my lord.
The
My-
rent was 35 paisa per square feet. The rent for each month shall be paid on the 7th of this month. For the purpose of payment, the dates will be counted as the month. That will, he will have the subsistence of the lease, pay all the rates and charges of every description. Then what happens?
Then I filed a representation
Or why?
for revising the rent, my lord.
Why?
Because as per their, my lord, page 29.
Ah.
That I have submitted, that I am to inform the government has newly revised the rent of open space at industrial estate
At,
as follows by letter number.
6 paisa.
So within municipal area, 6 paisa per square feet.
Then
Accordingly, my lord, I filed a representation. Page 30. With reference to the subject cited above, I have the warrant to inform you that kindly furnish a bill in respect of land lease rent with effect from September 2001 after necessary adjustment. The rates fixed and newly revised by the state government of Assam as understood. So the outstanding bill may be released on receipt of your intimation and the same was above.
Then
Accordingly, my lord, but they still date they did not pay any bill on revised rate. Thereafter, my lord, I approached before the learned civil court. The civil court, my lord, due to some reason, civil court dismissed my plaint. Thereafter, I filed title appeal. That was also dismissed. Thereafter, my filed second appeal before this honorable court. This honorable court, my lord, in oral expression saying that the civil court is not the proper jurisdiction. You may approach before the proper jurisdiction. Accordingly, I was told that you may withdraw this petition and file the proper case. Accordingly, my lord, page 80. This is the
was it
order.
in live streaming?
Page 80, my lord.
Live streaming?
Not my lord.
Then we can't know.
My lord,
Question,
kindly, my lord, say page 80, my lord. The order passed, my lord.
yeah. Then
That was at that time. It was not live streaming. Page 80.
wrong advice.
Mr. Chaudhary submits that owing to
As
wrong
the
advice, the
civil
appellant had to
court
move the
advised
civil
that he
court.
does not want to proceed to the demand, it must instead of exploring the possibility of intervening in demand in the past. Yes, then
Thereafter, my lord, annexing everything, my lord, I filed the state petition.
now what do you want?
I am saying that, my lord.
The rent should be 0.6%.
6 paisa. As per revisement, they furnish the rectified bill. I will submit, my lord. And
they have not considered it.
they have not considered yet, my lord. And till date, my lord, I have invested lakhs of rupees, which I have not accrued any type of.
Has the lease deed been extended?
Still date not extended, my lord.
So why should I pass?
That because matter is sub judice before this court, my lord.
So, but okay, for that period up till 2011, this court can say. Not after that, this court can't say.
My lord, that at that time, my lord, even that was a sub
Mr.
judice.
Counsel, if you are in a writ proceedings, one has to take note of that you are asking on the basis of a cause of action which arose in respect to a lease deed, which was in existence. Can I say till today? Because if I say till today, would I be not by my order extending the lease, which is absolutely the prerogative of yours and him? So the only thing I can consider out here is that during the period till that notice of the government was there that it should be 0.6%, 0.6%
Per square.
Per square feet.
or 6 paisa per square feet. That only I can consider only till then, till the date that any revision was not made by the government. I can't do further beyond that. And that too only for the lease period. Thereafter, if the lease has not been extended, you should be thrown out. Yes. What
My
do you-
limited submission is that, my lord, this petition itself is not maintainable, my lord.
Very well.
Because, my lord, the reliefs, my lord, which they have sought in this writ petition, they have sought the similar reliefs in the case before the learned Municipal, my lord. If your lordship will kindly see page number 50, the reliefs, my lord, for a declaration that the plaintiff is entitled to get rectification of lease deed.
Page?
50, my lord, 50 of the petition. So, my lord, the issues involved,
50.
for a declaration that the plaintiff is entitled to get rectification of lease deed dated 17/7/2001. At
For
the rate,
declaration, the plaintiff is entitled to give
Yes.
a bill of the rent for the schedule permitted for declaration that the deed of lease dated when to be renewed after the expiry of the present term. That's when.
but all these issues were already discussed and decided by the learned court below, my lord. And that judgment was also upheld by the court of civil judge, my lord, on 2 counts that, my lord, they are a defaulter because they did not pay the rent, and within 6 months, they must have set up the industry, which they did not. In these 2 counts, my lord, their suit was dismissed and it was confirmed by the appellate court, my lord. Thereafter, my lord, they filed a second appeal. In the second appeal, my lord, they decided to withdraw it without challenging the judgments passed by the Municipal and the first appellate court, my lord. So, in that case, my lord, the judgments passed by the lower courts, they remain in force.
And
So, my lord, this petition, my lord, there is nothing to be adjudicated in the petition because whatever, my lord, they have prayed for in this have already been discussed and decided by the civil courts, my lord.
My lord, here in this case, is the facts is little different. I filed second appeal, my lord. In a second appeal, withdrawn, my lord, on a special circumstances. So you approach
we
before
should have
the,
filed the writ petition before that very judge who made that oral expression.
that was, my lord,
Now he's long retired. What to do? I can send this matter also to him.
so at this stage, my lord, this is a rate.
At
rate
this
for-
stage, the only thing is you may ask the President of India to again appoint him. Otherwise, your writ petition is to be dismissed.
My lord,
This court cannot consider because the civil courts have already decided this aspect. There's no way out. Tell me.
this is the, my lord,
I
rate-
have, yeah, but the fact that how can this court take note of this when the civil already wouldn't the principle of res judicata apply?
This is right.
Then if there is already a finality now by way of another proceedings under 226, can I resort to this? Very difficult. Can't help you.
However, my lord, this is a 226, my lord, jurisdiction.
So,
So, my lord,
res judicata would not apply.
apply, my lord. But
Then?
this is the civil court, my lord, which is subordinate to this court, my lord.
Subordinate, there is no subordinate. Civil courts are not subordinate. This court is not exercising 227.
This is right, my lord. This is
So
right.
this court is not exercising. This court is 226. So under such circumstances, this court is not the civil court is not subordinate to this court.
Not subordinate in sense for my 227, but in 226 also, my lord, this court can exercise jurisdiction over the learned civil court, even in 226, my lord.
Very well.
Although, my lord, cannot we say the subordinate under 226, my lord?
This court,
Okay.
any order passed out here would be interfering with the order passed by the civil court. Would be interfering with the decree passed by the civil court, which has attained finality. How do you take care of that situation? I'm coming in 5 minutes. Think about it.
Respondent number 4 and 6 of ASI. All 6 here. ATM method. 4 and 6 of ASI.
On the question of jurisdiction, where is the judgment?
Will court judgment, my lord, massive judgment, page 53.
Page 53, my lord.
Whether the truth is maintainable in the form. What is issue number 1?
Issues are at page number 55, my lord.
So the suit was maintainable. If the suit was maintainable, it was not dismissed on the question of jurisdiction. There's no way out. Can't help.
My lord,
I may be allowed to sometime, my lord. I may be allowed to sometime to place some citations, my lord. In 226, my lord, your lordship may interfere this order.
Not possible.
Well, they ought to have challenged the judgments on the ground that they have violated the fundamental rights of the petitioner. Then that would have been different, my lord. They have not done so.
My lord, allowed some time, my lord. Some citation may be allowed to place, my lord. Say, even in 226, my lord, your lordship may, otherwise, my
Will
lord.
not, under 226, this court cannot set aside any interference with that order. Would be touching on the finality attained in the or civil proceeding, which this court cannot. I have all sympathy for you. But
My lord,
the
here
fact
in this case, my lord, consider my aspect, my lord.
I
I have paid lakhs, I have spent lakhs of rupees, my lord. Only because of their, my lord, they did not issue NOC for electricity connection. So I cannot proceed, I cannot start, my lord. So under, it is everything, my lord, due to the fault of them, my lord, I am the sufferer, my lord. And in the year 2001, my lord, I have spent 5 lakhs rupees in the year 2001. And the laborer who works, my lord, who is in examination before the learned municipal, my lord, examined and deposed that yes, he received 75,000 rupees as a labor charge. So consider my aspect in this way, my lord. Otherwise, my lord, nothing, my lord, for the last 20 years, they hanged me in this way.
okay, only one thing this court can help you out is as regards the NOC. That's what this court can help, because that is not a part of the relief. Others is this NOC. But this NOC will be subject to you paying his due.
Lord, if your lordship will see our affidavit, my lord, they were given 2 chances to pay the area, my lord.
But you have not evicted them.
No,
No,
but the lease agreement was cancelled, my lord. Page number 122.
And you have not challenged the cancellation.
Cancellation of allotment.
Have you challenged the cancellation?
Cancellation have not challenged, my
Yeah.
lord. That cancellation, my lord, I have found, my lord, by his affidavit, my lord. Otherwise, that was not served to me, that
And
cancellation.
also you have not challenged the cancellation.
That cancellation was not served to us,
Then-
served to me, my lord. So I did not receive this cancellation. It
Are
is-
you saying that you did not, you the defaulter and had not paid the monthly rent or a year so and so from the first notice of New Year, and the total amount is 30 lakhs in the area? Did not pay any amount,
And that bill is issued during the,
paying the notice. You have also filed an IA in some day, IA civil
yeah, that,
3010.
that bill was, my lord, that bill was served to me, my lord.
And-
But we are saying that that the revised rent, that bill may be paid. So I filed this IA during the pendency of this writ petition, my lord. The my lord
Is a
sent this
notice
bill.
of
my lord.
cancellation. So this was cancelled on 1/2/2023. You have not challenged that also.
And that my lord, they submitted in affidavit, my lord. This is not served, my lord. My client did not
Mr.
receive.
Counsel, the affidavit was filed on 17th of August 2023. We are in October, January, February 2024. As of now also, you have not challenged that. How can this court now, in view of the cancellation, even give the question of no objection certificate?
My lord, I may be allowed to,
Nothing.
I may be allowed to sometime to challenge this cancellation order, my lord. That at least, my otherwise, my lord, for the last 20 years, my lord. They, in otherwise, my lord, I have approaching again and again that punish the bill in a rectified form. They did not, my
The
lord.
instant writ petition has been filed by the petitioner, seeking the following relief. Page 13 of the page, 1, 2, 3. Pending disposal to nullify. 1, 2, 3. The facts of the instant case is that the petitioner was granted an allotment of land at the industrial estate Bhadarpur Ghat, subsequent to an application filed by the petitioner on 6/1/2000. This aspect was informed to the petitioner by the communication dated 7/7/2001. In the said communication, it was specifically mentioned that the land rent of the area of 7056 square feet would be at the rate of rupees 0.35 paisa per square feet per month, subject to the revision and enhancement of the rates as fixed by the government from time to time. The petitioner was also directed to execute a lease deed in that respect. Accordingly, on 17/7/2001, a lease deed was entered into by and between the Assam Small Industries Development Corporation Limited and the petitioner. In the said lease deed, it was specifically mentioned that the lease was valid for a period of 10 years from the date of execution of the deed of lease, provided that at the expiry of the present term, the lease may be renewed with the mutual consent of both the parties, subject to the execution of legally valid documents. In the said lease deed, it was also stipulated that the amount to be paid as lease rent would be 0.35 paisa per square feet. Subsequent to the issuance of the lease, subsequent to the entering into the lease deed, the General Manager, District Industries and Commerce Center, Karimganj, had issued a communication to the petitioner informing that the government had newly revised the rent of the open space at the industrial estate by the communication dated 5/9/2001, whereby within the municipal area, the revised rent was 0.06 paisa per square feet per month with effect from 1/1/2000. And for outside the municipal area, it was 0.30 paisa per square feet per month with effect from 1/1/2000. On the basis of the said communication, the petitioner submitted various application representations to the respondent authorities, concerned respondent authorities, for the purpose of revising the terms in the terms of allotment as well as also in the lease deed. However, the respondent authorities did not take any steps in that regard. And on the other hand, raised bills on the basis of the lease, on the basis of the lease rent as stipulated in the lease deed. The same the said process, the petitioner also did not pay the lease rent, although demanded. That, however, taking into account, it is also relevant to take note of that as the lease deed was valid for a period of 10 years, the petitioner submitted a representation on 7/2/2011 to the General Manager, District Industries and Commerce Center, Karimganj, requesting for renewal of the lease deed.
My lord, this is not 2011, my lord, this is 2001, my.
Huh?
2000, I have submitted revision 14/3/2002, my lord. And application, my lord, 2001, my, the zonal manager rectified this bit.
Mr. Counsel,
Page
in
30.
page 39.
Later one. But before that, I have furnished this.
It is, however, relevant to take note of that in the said communication, there is a mention of a writ proceedings being WPC number 4672/04. What is that petition for?
This repeat.
4672/04.
And this is the writ petition. There, before that, my lord, I have not filed any other writ.
There is a mention out here, page 39. In fact, you have earlier challenged this aspect. It shows from the contents of it.
No, it was with regard to some loan agreement or something like that, banking transaction. I have
Is
checked
it?
on the internet.
Is there nothing to do?
My lord, my only submission here.
Whether is it me? In addition to the said representation to the General Manager, District Industries and Commerce Center, Karimganj, the petitioner also submitted another representation on 11/3/2011 to the in charge Zonal Office, Assam Small Industries Development Corporation Limited, requesting for renewal of the deed of lease. And at the rate at the revised rate of 0.06 paisa per square feet. The record further reveals that the respondent authorities did not do anything, did not respond to the said communications, for which the petitioner filed a suit before the court of the Municipal number 2 at Karimganj, being title suit number 160/2011. The relief sought for in the said suit is reproduced hereunder, page 54, paragraph 78 here. The said suit was duly contested and thereupon by the judgment and decree dated 26/5/2013. The said suit was dismissed with cost on 29/6/2013. It was dismissed. The petitioner being agreed preferred an appeal before the court of the civil judge, Karimganj, being title appeal number 35/2013. And the said appeal was dismissed by the judgment and decree dated 16/6/2014. The petitioner thereupon preferred a second appeal before this court, which was registered and numbered as RSA 161/2017. However, the said second appeal was withdrawn with liberty to move any appropriate forum subject to prevailing law. Was withdrawn on 29/5/2017 with liberty to move any appropriate forum subject to the prevailing law. Thereafter, the instant petition has been filed. This court by then, thereupon the instant petition was filed on 11/8/2017. This court by then order dated 29/2017 issued rule the record further reveals that the respondent number 4 and 6 have filed an affidavit in opposition, challenging the maintainability of the writ petition on the ground that the reliefs which have been sought for have already been rejected by the civil court, and the decree so passed therein had attained finality. It was also mentioned that the petitioner was given various notices for payment of the outstanding amount of rupees 30,62,393 and was also given a notice to the effect that if the petitioner failed to make the payment, the lease deed, the allotment would be cancelled. In spite of the said, the petitioner did not pay the said amount, for which, by an order dated 1/2023, the said lease deed, the said allotment was cancelled for violation of the prime condition of allotment made for establishing and running the industrial unit in the said allotted premises. In the backdrop of the pleadings, this court have also heard the learned counsels appearing on behalf of the parties. and have given due consideration. Full stop. From the respective submissions and as well as the pleadings, 2 points for determination arises for consideration. One, whether the instant writ petition is maintainable. And if so, what reliefs the petitioner is entitled is maintainable. Number two, whether the parties herein are entitled to any reliefs as has been sought for. Next. This court in the foregoing paragraphs of the instant judgment have already taken note of, had already quoted the reliefs which have been sought for in the instant writ petition, as well as the reliefs which have been sought for in the plaint of title suit number 160/2011. This court have also perused the parties in the instant proceedings as well as the parties in the said suit, which are one and the same. From the reliefs which have been quoted here in above, it would be seen that except the relief in the present writ petition to issue a no objection certificate to the petitioner for drawing up an electric connection, all the other reliefs were part of the civil suit, so filed by the petitioner, which was dismissed and the said attained finality. Under such circumstances, it is therefore the opinion of this court that other than the relief sought for in the writ petition, that is, to issue a no objection certificate to the petitioner for drawing up an electric connection, all the other reliefs have already been decided by the civil courts, and the said judgment and decree had attained finality. Under such circumstances, this court, under Article 2 to 6 of the Constitution, cannot interfere. And under such circumstances, this court, under Article 2 to 6 of the Constitution, cannot grant the reliefs which have been sought for in the instant writ proceedings. More particularly, the reliefs at serial number Roman 1, Roman 2, and Roman 4. In as much as this issuance, in as much as granting any relief, granting the said reliefs would amount to sitting over a judgment and decree passed by the civil court which has already attained finality. Next. As regards the relief pertaining to issue no objection certificate to the petitioner for drawing up of an electric connection, it is the opinion of this court that as the lease deed was valid for a period of 10 years, that is, with effect from (17/7/2001) to 16/7/2011, and there has been no fresh lease deed executed. Any direction so passed would be in essence extending the said lease deed, which have also been rejected by the civil courts in the judgment and decree. Further to that, the lease, even the allotment of the petitioner was cancelled on 1/2/2023. As could be seen from Annex C to the affidavit filed by the respondent number 4 and 6. And the said order have not been set aside by any competent court of jurisdiction. Under such circumstances also, the question of issuance of granting a relief to the extent of directing the respondents to issue a no objection certificate to the petitioner for drawing up of the electric connection does not arise. Consequently, the instant writ petition, this court finds no ground to issue the writs which have been sought for in the instant writ petition, for which the writ petition stands dismissed. I was closed on the last occasion. Okay, this was for early disposal, na?
Early disposal. No, my lord. This was for during the pendency of the petition, they furnish a bill, which I have challenged through IMI.
I think.
Highly obliged.
Obliged.
Yeah, it's a lordship. 1 week accommodation may be given for fine hearing, my lord. Pleadings are complete, my lord. Pleadings are complete. Respondent have filed a response. Affidavit in oppositions, my lord. It may come up for hearing, my lord.
What is this matter about?
My lord, for respondents non-granting the exemption for the substantial unit of the company, my lord. Under any IPP, we have challenged the illegal and
Impugn
arbitration.
orders may be not issued. Forbear from giving effect to the impugn orders may not be issued to acquire between a manner to keep benefit of central exemption under current today. Existing unit of the petition of commencing not undergoing. You have filed affidavit?
Yes, Lordship.
What is your stand in the
I
affidavit?
would stand that they are eligible for granting exemption as a new unit, not an existing unit. Because immediately they start their commercial production from 1/4/2008.
Then?
So they are entitled to a new unit. Their contention is that they may be allowed to issue NOC that are existing unit. And as per clause 5B of the 2007 notification, those units who has started commercial production from 1/4/2007, their unit will be considered as an existing unit. Not as
What is the difference existing and new?
because from the 2000.
25%.
Yes, sir.
Yes.
Yes, 20
Only to the extent of,
expansion,
only to the extent of expansion.
expansion,
And they are claiming that for the entire,
entire. And our contention is that their unit can be considered as any uniform.
then
Except that was, we have rejected their application for granting NOC. They are entitled to considered as a old unit and for expansion. They have challenged it.
then why the petitioner is delaying the matter?
We filed a affidavit in November 2020.
2020, and you have not filed a reply. On that ground itself,
My lord,
can't help it.
1 week maybe accommodate
For what?
for hearing, because arguing counsel and Haveli, she's out of station, my lord.
No, I can't help you. You are there. No, the question is, how can, if they have mentioned something
Yes,
that it cannot be done, unless you say it is on a question of law, so then we are going to see on the question of law.
my lord, some
The
time.
facts they have already stated,
Yes,
you
ma'am.
have not denied. Therefore, the facts are there. Only on the question of law as to whether there would be a new unit or an existing unit.
My lord, time may be granted for reply then, my lord.
What reply?
For affidavit.
What
reply
reply?
if required, 20.
Just the cost of 50,000.
Oh, my lord. 1 week may be granted, my lord. Only 1 week.
50,000 cost. No, reply has to be 50,000.
No reply, then my final hearing,
Don't
my
file
lord.
reply, it's okay. You have not filed a reply. If you file a reply, cost it.
Reply back.
You can file a reply whenever you feel like.
No, my lord, then it can maybe posted for hearing, my lord, in the presence of this counsel, my lord. She's out of station, my lord, out in counsel.
You want the matter to be fixed for hearing?
Yes, my lord.
Hello? We'll issue rule. The learned counsel appearing on behalf of the petitioner submits that the pleadings are complete. It has also been submitted that the rule may be issued in the instant writ petition. And the instant writ petition be admitted and accordingly fixed for hearing. Taking into account Mr. Ezekiel, the learned counsel appearing on behalf of the respondent, submits that he has no objection as regards admitting the writ petition. Taking into account the writ petition is admitted by issuance of rule, list the matter for hearing in its usual course.
Seven.
Mr. Lordship.
Hmm.
Also, sincerely apologize for the last date, Lordship. My name was actually not reflected in the list, Lordship. Instead of my name on B, Chaudhary's name was appeared in the list, actually, Lordship.
Now what is
Now
to be
the
done?
department has the instruction, said that 1 week time may be allowed for the instruction, Lordship. Only
Or
1
what
week time.
instruction? This is that matter.
Yes, Your Lordship.
For one area amount matter, actually department has told that they have not communicated yet from
LOC.
LOC scheme.
LOC scheme. Whether
You have been exonerated.
Then acquitted.
Then you are
Again
entitled to
approach.
that
yes.
amount.
only 1 week time may be allowed, Lordship. The department has not
Has your name been reflected today?
no, Lordship.
Today,
Mrs. M. Miss M. Kotoki, na? The learned counsel appearing on behalf of the respondent, Animal Husbandry and Veterinary Department submits that on the earlier occasions, the state counsel could not represent as her name was not shown in the cause list. Taking into account the above, this court directs the registry to show the name of Miss M. Kotoki as the standing counsel of the Animal Husbandry and Veterinary Department in the cause list. Ms. M. Kotoki further submits that 1 week's time may be granted so that the instructions can be obtained from the department as regards the entitlement of the petitioner. Taking into account the above, list the matter again on 15th of February 2024.
Obliged.
The record reveals that in pursuant to the order dated 8/1/2024, no report has been submitted. By the Civil Judge Junior Division number 1, Karimganj, as regards the execution proceedings. Being execution case number TEX, case number 15/2005. List. Huh?
The last date was on 18th of January, but I was trying to.
Don't show all these old things. I've already looked into all these things. Last order was passed on 8/1. I've looked into it. Taking into account the above, matters stand adjourned to be lifted again on 13th of March 2024, on which date the registry shall ensure that the Learned Civil Judge Junior Division number 1, Karimganj submits the report as sought for by the order dated 8/1/2024.
9.
Yes, what is this?
My lord, in this case, my lord, a room was allotted, my lord, the petitioner's father, my lord, by the Lanka Municipal Board, my lord. My
Then
lord, after that, my lord, the respondent number 5, my lord, somehow managed, my lord, a file level joint application, my lord, with the name of my lord petitioner's number 1 and my lord, his name, my lord. So, my lord, the petitioners filed, my lord, the representation before the deputy commissioner and other, my lord, authority, my lord. But till then, no disposed, my lord. This representation was not disposed of, my lord. And my lord, but he is a, my lord, government employee, my lord.
Who?
My lord, the respondent number 5, my lord.
His name is there in the allotment.
Lordship, after when I joined
Which department does he work?
municipal board, my lord.
Same board.
Lanka Municipal Board, yes.
He is an employee.
Yes, lord.
And his name has been incorporated.
Incorporated, my lord, in the year, my lord, 1994, my lord, after filing a joint application. This has come, my lord, came to my knowledge, my lord, after filing the affidavit filed by the respondent number 4, my lord, executive officer. So, my lord, petitioner subsequently, my lord, petitioner filed, my lord, FIR, my lord.
I am representing respondent number 5.
That signature was
I am
also
representing
false,
respondent number 5, my lord.
Yes.
My lord, he referred to Rule 12 of the Assam, my lord, Services Conduct Rules. That provides for, my lord, that indicates what is the government, who is the government employee. Here is a case, he is not the government employee. He is the employee of the board.
No, I'm not. Who has granted the allotment?
At that time, my lord, what happened, my lord?
No, who has granted the allotment?
My lord, board, executive officer of the board.
That municipal board.
Yes, my lord.
Has granted the allotment to you.
Yes, my lord. Not only me, my lord.
Knowing fully well that you were an employee.
At that time, I am not employee, my lord. I tax collector. Tax collector, they have collected tax with
Now
certain.
you are an employee.
Not, my lord. Employed for the purpose of collecting tax.
Now are you an employee?
I am retired, my lord. I am not no more employee.
in the year 2022, my lord. Petitioner,
My lord, what
petition
happened?
filed in the
My
year
lordship,
1990,
lordship, I take the affidavit of government, my lord. Lordship, kindly see. That
My lord,
the
they
affi-
admitted, my lord, in that.
My lord, yes, my lord. Lordship, kindly take government affidavit, my lord.
Where?
My lord,
Who has
affidavit
filed?
filed by the government, my lord. Respondent number, executive officer, respondent number 4, my lord.
Tell me.
Lordship, kindly see. I challenge this, my lord, his maintainability of the writ petition on the ground that, my lord, the action was taken in 1994.
Your name was inserted.
Yes, my lord, in the year 1994, with the consent of his mother, and he was also an co-applicant in the said application. From the record, I'll show. And thereafter, my lord, till 2020, both of us, writ petitioner as well as me, enjoying the beta jointly, my lord, by paying, my lord, revenue to the government.
Both of you?
Yes, both. Next, my lord, he has suppressed the fact that he is also a government employee. He is the employee of the board.
Yes,
In
my
the
lord,
entire writ petition, and
You are also a board employee.
yes, my
no,
lord.
not only, my lord, kindly see, my lord,
Lordship,
their affidavit, my
just
lord.
I'm
My
clearing
appointment letter, my
clearing
lord,
the
kindly
fact.
see, my lord.
He is also a, my lord.
Now the question is, who is the bigger cat?
That is the problem.
He
My
is
lord.
the-
And he has suppressed the while filing the writ petition. He is well aware of the fact that he's the employee of the board, but he has not made any mention about his position. Rather, he has mentioned that he's an unemployed. Paragraph 6. Next, my lord.
Wait. Let us see. Why should we go further beyond that? If
Yes,
we
my
have stated that false statement.
Lordship, kindly see paragraph 6.
The petitioners are being unemployed and due to sudden demands
Yes.
of the have no other option but to approach for family to ensure according by verbal permission the respondent author allowed the mother of the petitioner, namely to run the least allotted spot, and thus the mother of the petitioner was running the said spot till her death. But during all this period, the name of the petitioner's father was used for making monthly payment by the respondent, but it was not given in his name. It was given in the name of the mother.
Mother, my lord, till 1994. From 1994 onwards, his name and my name was there, my lord. In the
Where?
affidavit of the government, Lordship, kindly see, executive officer that I referred to, my lord. We are jointly paying the revenue.
I can state that after the demise of the petitioner's father, the mother so filed an application to state authority.
And he's saying he's the unemployed man.
The vita in the name of so call number 5 and Iman on 12/9, and a joint petition has been filed by the petitioner. He has to transfer the vita in their name.
Yes, suppress the fact that he's an employee.
So this is a false statement if this is true. If this application is there of 12/9/94 by the mother as well as you have also jointly done it,
Yes.
that is a suppression of the false statement.
Yes, my lord, kindly see the affidavit filed by the government, my lord. My
What is
appointment letter, my lord. My appointment, play game, my
No,
lord.
forget about the appointment letter. I'm telling you. You say that the mother's, it was allotted in the name of the mother from 1994 in paragraph number 6. Accordingly, by verbal permission, the respondent allowed the mother of the Iman, and thus the mother of the petitioners were running the said shop till her death on Iman. But during all this period, the petitioner's father was used for payment, was also without any objection, was receiving rent in the name of the deceased father. Annexure E.
Yes. In the affidavit, my lord, board has furnished the document to show that jointly we are paying, my lord, revenue from 1994 onwards, my lord.
14/9/1994. And your application thereafter was made on 12/9.
He filed the application only in 2018 and 19, my lord.
That is my case, my lord.
And show me thereafter, why only of 2019-94? Thereafter, what you must be submitting any receipts?
Yes, my lord. I am not submitting, my lord, but there is no in my record, my lord.
No. There, you say that it has been all along thereafter till 2012. It has been submitted in the name of your father.
Yes.
You have stated that.
Lord.
Now, kindly prove it on the basis of a document that after 14/9/94, you have submitted anything in the name of your mother or in the name of your father.
My lord, that is the, my lord, my case, my lord. After that, my lord, the respondent number 5, my lord, somehow managed, my lord, his name, my lord.
Since
12/9, that is the petition.
Since
12/9/1994, my lord. After filing the joint petition, my lord. That is a fake documents by signed by my petitioners number 1, my lord. That is why, my lord, petitioner filed, my lord, FIR, my lord.
If that be so, my lord, this is a dispute.
My lord,
no. In 1994,
yes, 12/9/1994.
you have thereafter you have submitted. It has been all along in your name. Now you have come to know.
Yes, after filing the.
After filing, you have come to know.
Lordship.
All along you have been depositing your rent. Kindly come to paragraph 6. Accordingly, by verbal permission, the respondent authority allowed the mother of the petitioner, namely so-and-so, to run the said lease shop, and thus the mother of the petitioner was running the shop till her death. But during all this period, the name of the petitioner's father was used for making monthly rent by the illiterate mother of the petitioners. The respondents also, without any objection, was receiving the monthly rent till 14/9/1994. Now, when did your father die?
My lord, that is 87, my lord. 24/5/1987.
Okay.
Paragraph 5, my lord.
Yeah. And thereafter, you have not paid.
My lord, I have paid, my lord.
Have you paid any rent receipt? Because this, your mother was running till 2012.
12.
Did you pay any rent?
That, yes, my lord, but that receipt, my lord, I have not received, my lord, in my record, my lord.
No. Have you paid any amount after that till your mother? Till your mother or till the filing of the writ petition? Have you paid any, made any deposit of the rent?
That is a joint rent, my lord, but paid by me, my lord.
If you have paid, you have got a receipt.
Yes, my lord.
Have you got any receipt in the year 1995?
1995, my lord, that record, my lord, I have not, my lord.
No. Because here is the case.
Yes.
Otherwise, why are you filing the writ petition in the year 2019? There's a question of delay.
Right.
If you have been all along paying, because you have to pay the rent,
Right.
or else you are not paying. There has to be only two considerations. Either you have paid or you have not paid. Now, if you have paid the amount, you will have a receipt.
My lord, that day, my lord, in 2012, 1994, but that game, my lord, already, my lord, done by the respondent number 5, my lord.
So after, therefore, are you saying that after 1994, you have not made any payment?
No, I have paid, my lord.
Where is
But,
the
my lord,
receipt?
that, my lord.
No, then if you have paid, they will, do they issue receipts?
Receive, my lord, yes, my lord.
And if they have issued receipt to you,
Yes.
whose name would be there?
Jointly, my lord.
Then why you have approached in the year 2019 after 19 plus another 6 years, it would be 25 years.
My lord, that period, my lord, I was paid, my lord, my revenue, my lord. But, my lord, when, my lord, the knowledge.
Mr. Counsel, why have you approached after 26
Well,
years?
before that, my lord, I have filed representation, my lord.
What about the representation? When did you first,
File
when did you submit your representation?
2018 and 19.
18, my lord.
2018 and 19. he filed
You
it.
have submitted your representation on 4/5/2019, 4/5/2019, that's all.
Yeah.
Then
And he has suppressed the fact that he is an employee.
My lord, kindly see my employee, my lord. I am not a regular employee, my lord, kindly appointment letter, my
He
lord.
said unemployed.
My lord, kindly see my lord, appointment letter, my lord.
And my lord,
Government
executive officer- my lord, he is the government employee, executive officer has.
I'm not going to go into all this. First and foremost, it's a pure and simple case of a delay for which I'm dismissed. Or you better file a civil suit, whichever you pick. If I delay on the dismiss it on the ground of delay, matter ends for you for all time.
My lord, that shop, my lord, in now, my lord, with my lord, the respondent number 5, my lord. Is my lord 4 person, my
See,
lord.
the question is, now you say that it is a fake document.
After filing the affidavit.
Now, after this filing, if it is a fake document, if you are saying, can this court look into it?
My signature also false, my lord.
Can this court look into it? You are to show that yes, it is a fake document. Show it before the
How, my lord, petitioners came, my lord? No, my lord. Because, my lord, already, my lord, in the joint petition, they filed, my lord. He filed, my lord, and
you say, are you not saying that this is not your signature?
Yes, my lord.
So where can you prove that?
There is one file FIR, my lord.
Counsel, you can't prove that by filing an FIR. What will happen at best? If you file an FIR, you may be convicted. Then, does anything happen? This conviction will happen after. What is your age?
Petitioner says, my lord. Time of filing, my lord, he was, my lord, 50 years.
50 years. So by around 80 years, you may get a conviction. So wait till another 30 years. You have already waited from 26 years.
My lord, last receipt, my lord, petitioner annexed, my lord. That is, my lord, base.
Mr. Counsel, take my advice. Go and withdraw. Giving you, now you have come to learn on the basis of an affidavit. Then on the basis of that, you go and file and say that this is a fraudulent document. I have never signed. This is how you do it. You have filed an FIR, but the only way is you are to seek for cancellation of it because this is based on a fraud document. This court cannot decide this.
My lord, even then, my lord, the municipality property, my lord, the section 63 strictly, my lord, is stated, my lord. The respondent number 5, how it is, my lord, continued, my lord. If, my lord, he is continued, my lord, the respondent number 5, particular sub, my lord. The section 63, my lord, is strictly stated about, without, my lord, consent of the, my lord, the state government, my lord. Because, my lord, tomorrow, my lord, if, my lord.
Whatever happened,
then,
my lord, it happened in 2019,
that sub, my lord,
1994.
will be, my lord, with the hand of, my lord, respondent number 5 only.
And he has admitted the position that, my lord, we are jointly paying, my lord, revenue.
In this regard, my
Yeah.
lord, your lordship has already one passed, my lord, one judgment.
But that is not your prayer.
That is true, man.
I know, 62, 63, I know. The thing is that you cannot have it more than 2 years. 1 year, and if it is more than 1 year, you have to take the permission from the director of municipal administration. Law is very clear on that.
And
So
last,
that is not the issue.
last occasion, my lord, on 22/9, my lord. The learned engaged counsel, my lord, as Bothag was appeared, my lord, and your lordship has, my lord, raised, my lord, that point, my lord. Rule 60, section 63.
I say it, yes. But the thing is, on your part also, what your relief which you are asking for is yours should be cancelled. Are you saying that yours also should be cancelled?
Then well, it is better, my lord. That it will be better. Otherwise, my lord, he is the one is strong, my lord, everything well, he knows, my lord, how to handle, my lord, the municipal authority, my lord.
Now I am a retired employee of the municipal board.
Because he's, my lord,
And, my lord, whatever happened in
Who is appearing for the municipal board?
he is appearing.
I am for the, my lord, chairman.
And he is also admitted,
Now
my
tell
lord.
me, how can you grant the allotment for so long? Is it a hereditary right?
My lord,
Is it a hereditary right?
no, my lord, no.
What is the right? How do you give municipal property?
But the
Oh,
chairman came into, my lord, I was in the office in March 22 only, my lord.
Huh? I'm not on that. I'm asking you. You are a lawyer. Tell me, under what provision you can allow a municipal property to be used for all times to come? Can you allow it?
My lord, earlier he was granted while you are not an employee, my lord.
Forget about the employee, non-employee. I'm not concerned that. Have you ever looked into the provisions of section 62, 63? Have you looked into the provisions of section 143 or 144? What is that, Mr. Dinia?
63, my lord.
62, 63, and then 142.
48, my lord.
148.
Lordship.
And have you looked into the how the pounds and mahals are to be looked into? Sale of pounds and mahals. Pounds and these are pounds. How are you? Can it be permitted to be in eternity? No. Does the hereditary right encroach upon them? Then file an affidavit as to what is the right as regards the municipal property. File an affidavit. Let us see, because this is very necessary. Not only that. Who is, yes, government. Is the director of municipal administration a party?
Lordship.
Yes. Mr. Borua? Mr. Borua, you have to file an affidavit, being the director of municipal administration, as to whether a municipal there is any hereditary right, whether there is a transferable right, whether there is a right in perpetuity in respect to a property, municipal lease being granted. File an affidavit. Because that is a very important thing where every day I get a case to the effect. And that day also I passed the judgment that that is not possible to do.
If it's the bequeathed from family members one to other.
What is all these things being going on bequeathed?
That is
Show
not
me a
true.
provision by which let us see, because normally the settlement has to be given for 1 year.
1 year.
And it may be renewed
Yeah.
for whatever you mean, but it has to be made 1 year.
1 year.
And thereupon, if it is for 2 years, you have to take the permission from the director of municipal administration. Now nothing is there. Now, how do you make the settlement? The settlement has to be made by sale. Every year you have to sell it. Nobody has accrued right over the municipal property.
Wait,
File an affidavit.
I will file
Let
it.
us, then if we can close and fill up this gap, then we can very well dispose of many of these unnecessary matters. Stop coming of these matters. Because the government has to take a decision. Okay. List the matter when? List the matter on 15th of March 2024. In the meantime, the Director of Municipal Administration is directed to file an affidavit on or before 13th of March 2024. Stating, indicating the stand of the stand of the said authority as to whether the right in respect to municipal property as to what are the rights in respect to municipal property given on lease to the lessee, indicating therein as to whether the such right is heritable, transferable, as well as in perpetuity. Mr. Burwa, kindly do that. Once we get hold of this, because there is one judgment I have delivered. Give it to him. Cannot be done. There are many judgments to the record. You cannot. How can you? This is what is every day happening.
Majority of family members bequeathing one for another or in.
And they're selling it.
They're selling it.
They're selling it. They're
Subletting
selling it.
it.
Yeah, they're subletting it. Is it possible? Unless you do something, in fact, you need to work out on this sale of pounds and mahals. At that point of time, it is been done. Something has to be worked out. These are properties which are valuable properties.
Wait.
Like this. In item number 10 or 11, the petitioner has died after about 1 year back. So
What is this matter is about?
the matter regarding he filed a FIR before the authority that was not taken any action.
The Mr. D.A.K.M. the Learned Counsel appearing on behalf of the petitioner in both the petition submitted that the petitioner had expired. He further submitted that the subject matter of the instant proceeding was personal to the petition, and as such, the right to sue does not survive upon the legal representatives. Accordingly, the instant proceedings therefore stands abated and closed. Interim orders, if any, stands vacated.
Yes, Your Lord. I am for item number 13. Lord.
Very well. And who is for 12? Your name?
AMS Majumdar.
AMS. So 8707 is yours.
3026.
Oh. In 8707, your name has been shown as the counsel for the petitioner. Anyways, tell me. No one appears for the petitioner in the other. What is your case?
Lordship, in my case, Lordship, an impediment petition has been filed in the IA, Lordship. I may be allowed some time now to file an objection, Lord.
So what is your case?
Oh, Lordship.
What about the others?
Lordship.
Setting aside and quashing the mutiny of the minutes of the meeting.
Lordship,
held on Iman whereby it was decided to reconstruct the second RS Shita under commanding, directing to take appropriate on the discrepancies related to it.
Lordship, what happened, Lordship, the
Who has decided to reconstruct the second RS Pita?
Lordship, the respondent number, Lordship, 7 to 10.
7 to 10 are private authority.
Yes, Lord.
We are concerned who has done it. Yes, government, who has done it? This is to be done by the revenue. Yes, revenue.
The Lordship, the impugned minors is page 32, Lordship.
Page
32, Lordship. It is the additional deputy commissioner, Lordship.
I don't understand. What is
The facts of the, yes, Lordship. Facts of the case is the Lordship. The petitioner's father, Lordship, in Lordship had a Lordship periodic lease Lordship of 23 bighas of land, Lordship. And in 2011, Lordship, his father died, Lord. After his death, Lordship, the petitioner came to the office, Lordship, for putting his name in his name, Lordship. And thereafter, Lordship, when the respondents have done nothing, Lordship, he tried to inspect the land documents, Lordship. After inspection, he found that, Lordship, all the records, Lordship, has been Lordship erased some, and his father's names also, Lordship, erased, and these land documents have been, Lordship, many of the all from documents, Lordship, I have stated is, Lordship, they can found that 50% of page of original draft sheet book of second RS are missing. The selling map, allotment, registration, etc. of Moza friends are missing, Lordship. Then, Lordship, he filed an application, Lordship, to the Lordship Deputy Commissioner, Lordship. Then the Deputy Commissioner has done nothing, Lordship. Subsequently, he filed a complaint, Lordship.
Where is the to the Deputy Commissioner?
Lordship, I'm coming, Lordship. She filed a complaint, Lordship, against this, Lordship, respondent number 7 to 10, Lordship, page 11, Lordship. This is the complaint, Lordship. In the court of Chief Judicial Magistrate, Lordship. Then the Chief Judicial Magistrate, Lordship, after, Lordship, examining the Lordship, page 17, Lordship, the witnesses and Lordship, complainant, Lordship, that is the petitioner, Lordship, is taken cognizance, Lordship. And thereafter, Lordship, the respondent, Lordship, filed, Lordship, a revision petition against this cognizance, Lordship. On the plea that no sanction has been taken under section 100, Lordship, 197, Lordship. Thereafter, Lordship, in that revision petition, Lordship, the Lordship learned session report, Lordship, passed, Lordship, issue summon, Lordship, to the petitioner, Lordship, and state the impugned, Lordship, cognizance order, Lordship. But in the meantime, Lordship, the authorities, Lordship, they are the authority, Lordship, the respondent number 7, who is the Lordship Assistant Settlement Officer, Lordship, and some others, Lordship, they, Lordship, taken minors, Lordship, to reconstruct the disputed documents, Lordship. Lordship.
Yes, DC.
Lordship.
Why are you doing that?
We have filed the affidavit, Madam.
Hmm.
There, Madam, we have stated regarding reconstruction also, Madam. In the affidavit, Madam.
The patta number 40 of Moza Chandrapur grant was issued in favor of Mumtaz Ali. Who is Mumtaz Ali?
Lordship, this is their affidavit, Lordship.
No, understood. Who is your father? What is the name?
The petitioner's father, Amir Ali Sheikh. In place of Amir Ali Sheikh, they have done that, Lordship. And they have stated in their affidavit that it was
the names of Abdul Karim
erased,
were recorded in the map. There is no map such as speeding map, so and so. As regards the PR case number, Iman case to respond number 7, and there is allowing the revision, thereby setting aside the cognizance of. Your father's name was there.
Lordship was their lordship. And the land is still in the possession of the petitioner lord.
Okay.
But the document, when he went to the office lordship, he found it is lordship erased and like this lordship. And the respondent also lordship, in paragraph lordship, they are already with paragraph 7 lordship. They have stated that the Patwari, under whose custody the documents were there, Kaji Abdul, he has manipulated the record.
Who has?
The Patwari lordship, under whose custody the documents was there, the lordship, he has manipulated the record.
Then
they have stated lord.
Yes, my lord.
So the manipulation is
The
accepted by
manipulation
them
by
also.
Mohammed Kaji, by way of erasing the Patta, my lord, we have stated there, my lord.
Where is your name? Which document shows that your name was there in the second RS Patta?
Lordship, this is the main problem, lordship. Lordship, the petitioners is in the possession, lordship. All the documents was their lordship. When the petitioner went to the office, lordship, they found like this. Therefore, he could not collect the certified copies, etc.
Understood, but the fact is, as of now also you don't have. You have to show that you have something to do with the second RS Patta. Where is the document? If you don't have that document, can this court hold that you are a person equal?
Lordship,
because your entire basis was the criminal proceedings which have already been quashed.
Lordship, then against this criminal lordship, the judgment lordship of certain judge lordship, the petitioner approached this honorable court, which is also pending.
It's a different aspect of the matter, whether it is pending or not. I'm not on that, but as of now, there's no stay to that order. So under such circumstances, the proceedings is not there. So the first edifice of your case is gone. Now the second edifice of your case has to be on the basis that you have something to do with the second RS Patta. Isn't it required to produce some document to show that yes, you are involved in some way with this Patta?
Yes, his father's name is there.
Something. Your entire allegation is your father's name was there in the earlier Patta, RS Patta, and now they have removed it by making reconstruction, or they are going to make a reconstruction. Now, under such circumstances, if they are going for making a reconstruction out there, then the question is different and thereby you would be affected. But the question is, you are to show that your name is there somewhere in the second RS Patta, or your father's name. If you don't show it, how do you maintain your reputation?
Lordship, by this declaration, I have only lordship, to preserve these documents which they are trying to reconstruct, lordship, for the purpose of lordship.
Now, why should this court at all, after hearing and due consideration of the meeting of the Imam in connection with so and so, shall remain still? So we can dispose it with this.
Lordship,
Let them go ahead with the reconstruction or whatever maybe, but keeping
Lordship,
records, maintaining records prior to the reconstruction.
Lordship.
Your problem is solved? Isn't? Because they have also said out here that they require this reconstruction. There has been computerization. All these things are there. They require it. Let them do it. But by maintaining, keeping records of the earlier,
Earlier.
they can keep separately those records.
Right.
Because they are not going to erase or remove anything.
My lord.
Because that is not heard of.
Right.
Reconstruction will be some new documents will be prepared on the basis of the existing documents.
Okay.
So the existing documents should be kept intact and they may proceed with the reconstruction without touching on the existing.
Lordship. Lordship. Because we
What
have-
do you say? Revenue?
Yes, my lord. That.
Huh? This is a win-win
My
for
lord,
everybody.
We have stated in page 5, my lord, accordingly reconstruction
Hello.
committee. my
And
lord.
the documents may be in the safe hand, lordship. Otherwise, yes, there are some in nexus, lordship.
Whatever may be, you see, first of all, who are you?
I'm for respondent number 7 to 10, my lord.
Yes, what is it?
ADC and my register that file. Regarding CR case, my lord, that already been set aside by the landed. Lordship needs to-
That I have already submitted on your behalf.
Already
Then
stated.
My lord.
no. The instant petition has been filed by the petitioner. Seeking a direction that the minutes of the meeting held on 7/2/2019, whereby it was decided to reconstruct the second RS Chita and Jamabandi of Moza Thandipur grant under Olgapur Revenue Circle of Hailakandi district be set aside and quashed. And for a direction that the respondent number 3 to take appropriate steps on the representation dated 22/2/2019. This court have duly perused the materials on record. And from the said documents, it does not show as to how the petitioner is anyway connected with the second RS Patta in question. This court have also taken note of that the petitioner had filed a complaint before the court of the Chief Judicial Magistrate Hailakandi, which was registered and numbered as CR number 452C/2018. In the said proceedings, the allegations made therein relate to certain interpolation made in the second RS Patta.
Lordship. In draft Chital.
Second RS Patta.
The original draft Chitam.
The original draft Chitta of second RS Patta. Pursuant to the said application, the complaint case which was filed, the Judicial Magistrate First Class, Hailakandi, had issued process by an order dated 16/8/2018. It is therefore the case of the petitioner that if the respondent authorities are directed to make the reconstruction as to carry out the reconstruction of the second RS Sita and the Jamabandi of the Moza Chandipur branch, it would destroy the evidence in respect to the said criminal proceedings. This court, however, finds it very pertinent to take note of that the said criminal proceedings, however, have been quashed by the court of the session, by the learned session judge Halakandi in criminal revision number 46 of 2018 by an order dated 2/5/2019. Therefore, as on date, there exists no criminal proceedings. This court cannot also be unmindful of the fact that and this court cannot also be unmindful that the petitioner herein have challenged the said order dated 2/5/2019 passed in criminal revision number 46 of 2018 before this court, which have been registered and numbered as.
Lordship, I am giving Lordship.
Is it there or not?
Lordship.
Are you sure you have challenged it or not?
You have challenged Lordship. My liner friend has said Lordship. We have challenged.
3026.
No. Yes, challenge.
Huh?
Yeah, I have meeting.
Yes, challenge.
Mark.
Number?
I-
Okay, number.
I'm collecting.
Taking into account that the question as regards the interpolation so made in the draft chita of the second RS Patta is pending before this court in so and so. It is the opinion of this court that the documents which exist as on date in respect to the second RS Patta,
Lordship, it is criminal division petition.
second RS Patta, RS Chita, and Jamabandi of Moja Chandipur branch be maintained and maintained. It is also the opinion of this court that to make a reconstruction, to reconstruct the second RS Chita and the Jamabandi is absolutely within the jurisdiction of the authorities concerned, taking into account the administrative exigencies. Accordingly, the instant petition therefore stands disposed of with the following observations and directions. The records, the existing records in respect of second RS Chita and Jamabandi of Moza Chandipur branch, which was seized on 4/11/2018 from the resident of Mohammed Qazi Abdul Hakim Patwari, retired, be maintained be retained Good stop. Number two, The respondent authority would be at liberty to carry out the reconstruction of the second RS Chita and Damabandi of Moza Chandipur branch seized on 4/11/2018 from the residence of Mohammad Qazi Abdul Hakim. As per the provisions of law, and in doing so, however, the earlier records, the existing records, be maintained. With the above, the instant petition stands disposed, the interim order passed earlier stands vacated. I close. None appears on behalf of the petitioner on call. The petition stands dismissed for non-interim order.
Criminal petition number 351 of 2019. Over.
What? I have, on second itself, I have communicated.
To whom?
Home Department, my dear. The stand of the DC is that we are waiting to the.
No, it is from the DC, you have to get your instruction.
Because the, our last, instruction was from the Home Department.
No, maybe. See, as to whether an award has been passed or not, it is not for the requiring department to say. It is for the district administration to say.
I have written to the, because since the instruction came from the Home Department.
Understood, but you were appearing for the district administration also.
Yes.
So under such circumstances, it should have been from the district administration as to whether the award has been passed in respect to the land acquired from the petitioner, and it's so passed. When it was passed, and further to that, as to whether possession has been taken away and when the possession was taken. That's all. So under such circumstances, you were to get it from the, you would have got, because the possession would be taken by the district administration.
It was handed
It
over.
can't be taken by the home.
Right.
If the
It
home
was
has
handed
taken, then
over-
it would be illegal. Are you saying that the home will be taken?
No.
Home has taken the possession.
It was handed over to the Home people. For construction.
Handed over, so the district administration will take it.
Yes.
When?
Next week.
Mr. B.J. Kalukar, the senior counsel, appearing on behalf of the district administration as well as the home department, submits that inadvertently he had sought for instructions from the home department. Rather, he ought to have taken the instructions from the district administration. Which one? District?
Kamrup Rural.
Kamrup Rural. Taking into account the above, this court grants a further opportunity to obtain the instructions as sought for by the order dated 2/2/2024. List the matter again on
Only minor
13th of February.
Minor only 13th I will not be here.
15th of February 2024, on which date Mr. B.J. Talukar, the senior counsel, shall ensure that the instructions are received.
Worst of it.
Yes, what are these two matters?
Your Lordship, may take up the item number 15/9061. Basically, both the matters are similar. What has happened is that I've been was appointed as a transporter for transporting bulk petroleum product by my trucks.
The dispute relates to a particular period in respect of the distance from point A to point B and the rate that will be applicable. Rates are already fixed as per the terms. Only in the PVC with regard to the increase, and there was some difference that we are claiming. Secondly, for the distance between A and B, for the period, suppose my contract was from the year 2013 to 2017. For 1 year, there was a dispute as relating to rate. Say, for instance, I have to travel from High Court to Sunmari. The distance is 5 kilometers. For the period in dispute, they have taken the distance as, say, 3 kilometers. In all probability, this was a computer-generated problem. I have written to them. The response that they gave was at page 308. This is reference to your letter. We wish to clarify the payments were made as per prevailing rate kilometer. Here, with regard to distance, they have not given any reasons.
So what do you want?
I want a
Reason for the payment.
direction to the respondents, basically, to reconsider the entire, if I can be approach them and
Goodness, where
and because I have because the
you want some money, go and fight litigations.
no, because the issue out here is that for the period which is not in dispute, the distance they have given me, I want the same distance for the period in dispute. Because subsequently also they have given me for the same distance. On record, these are there.
So that is a case which has to be proved before the authority is concerned or before the court, not before this court.
Because the materials, same distance, they're not
Is it admitted anyway?
They're not admitting per se the thing, but
so what is the legal issue involved?
Once the rates are already fixed and the distance is not in dispute, the amount
of fact. It's a question of fact. What is the legal issue?
For the same period, can they deprive me when there's no dispute as regard to the distance?
But the dispute is as regards the rate.
Not the rate. If I'm to get for 5 kilometers and they have only paid me for 3 kilometers, when the distance is not in dispute, because if the contract is for 3 years, for first year they have paid me for 5 kilometers, for the third year they have paid me for the 5 kilometers, in between they pay me only for 3 kilometers. That's the only thing. Rates are there already.
Yes, why? 3 kilometers you have taken.
Well, kindly see the page of the LOA method, page 123 method.
Huh?
123 method plus 2.
Page.
123 method. 1 to 3 method. This is LOA method. But the petitioner harping on method clause 2.a method 26.
Okay, clause
2.a method.
Page 2.a. Where is 2.a?
The last method and bottom method east of the tank track.
2.a
method.
Page 123.
Then method 126 method. 126 method. Can you see method?
126.
It's an agreement method between the petitioner and the petitioner method.
Agreement. Yes,
Method.
2.a. Each tank truck could be attached to a particular loading location, storage the company as per transfer. The tank would be required to carry bulk petroleum from particular location X before terminal to transfer and others X would be.
Then 127 method.
Then
by specifically stated, but if there is a dispute, my lord, we can go for arbitration method.
Oh, that I know. But what is this? 3 kilometers and 5 kilometers.
Yeah, did every tank truck would install my BTS vehicular tracking system, my lord. Each tank truck would install a vehicular tracking system, install my BTS, my lord. Like it can be, my lord, tempered by the my lord.
Not an elegant.
That's why, my lord, we use my lord Google Map, my lord. So that is the procedure. I'll show, my lord. Now, my lord,
the basic issue is about 14 to 16, my lord. We have given him some distance that is called my lord RTK.
You have done on the basis of Google Map
Yes, man.
and you have paid.
Yes, man.
Where is your stand in the documents on record as per Google Map? Because you have not filed your affidavit,
Yes,
so we have to take it on the basis.
Yes,
An affidavit, if you have to file, cost has to be included.
Page 130, my lord. This is my lord, 6 point, my lord, C, my lord.
6 point.
C, my lord, page 130, my lord.
Transportation charges payable under agreement are based on the shortest route approved by the company on the round trip basis. A rate of current RTKM applicable to storage point where the tank was based on available with company which is entitled to devise safety. Where Google?
No, my lord.
Where does Google?
My last
Map
time,
say?
while reviewing the RTKM, from time to time, the SPCL may determine the RTKM of retail outlet by using suitable IT tools based on Google Map application.
Where Google Map? Oh, yeah. While reviewing the RTKM from time to time may determine RTKM of retail outlet by using a suitable IT tool based on Google Map application.
So, from 2014 to 16, my lord, we given him a particular RTKM, my lord.
The road was better.
Now, but from 16 to 19, my lord, there are change
The
in
road was closed. No, it became more. Obviously, that
Yes,
particular location must have
Yes,
been
madam.
closed.
So that they wanted that difference, my lord, date, my lord. From my lord, 2014 to 16 and 16. 16
So
to
where
19.
is your stand? What you are saying? Where is your stand? That is a clause. Where is your stand that that particular period that road was blocked or whatever may be, and as such, or there was a proper road at that point of time for which this has happened? Where is your stand?
Page, my lord, 308, my lord.
308, I have read it.
Yes, madam.
One liner.
So that they want the rate, my lord, the difference rate, my lord. We say, my lord, we have
You
given
say that you have paid as per route.
Yes, my lord.
Then where is it? You
But
are
if
saying
there is
you
a-
isn't it required for you to say that during this period this was the shortest route available,
Yes,
and as such we have paid you on that aspect.
at the time of,
Have you mentioned that anywhere, any of the document?
no, my lord.
So
That
you have to take it that you don't have a that stand.
From 2014 to 16, he has not raised in dispute, my lord.
Hmm?
From 2014 to 16, my lord, he did not raise any objection, my lord.
But there you are giving him 5 rupees or 10 rupees, whatever may be.
Yes, ma'am.
But for this you are giving him 6 rupees.
Only
That is his
after,
dispute.
only after expiry of this agreement, my lord.
Hmm.
Tender work, my lord. They have raised this issue, my lord. Because it is a tender for 5 years, my lord.
So 5 years is over.
Yes, my lord.
Now he is
From
raising
13
the
to 18, my
dispute.
lord.
I raised it in 2018 or itself.
The work, my lord, is of, my lord, from 1/9/2013 to 31/8/2018, my lord.
In 2015 also, we have raised to page 216.
So if you have raised the dispute, then why haven't you gone to arbitration?
Yeah, also for this, first of all, in 2015,
How is
the
your right
amendment,
under Article 14 violated?
you also may just consider this as
The
well.
right
To
is
2015,
violated because in the first year they have given you more, and the third year they have given more. So the
Because
violation is vis-a-vis you. There has to be something. Violation against somebody else. No. Violation is against you. Secondly, there is an arbitration proceeding. You
no,
can do that.
arbitration procedure, my submission is that in terms of section 12, this arbitration clause is not applicable.
So
Will
then,
be-
then you need to file an application under section 11(6).
Then, and the second, your lordship, the law or the issue that is involved, I'm not asking for rate variation. I'm only asking for the, you have, my categoric stand
Your
is that
stand,
the-
I have got it to know that your stand is that for the same distance where earlier you have given me 10 rupees, And later on also I have given 10 rupees. Why in the middle
It is-
portion you have
that-
given me
For
6
that,
rupees?
if I have to go and the claim amount is also not here, if the arbitration venue is at Mumbai, my, that will not be an efficacious remedy because arbitration is in Mumbai. Case 135, if your lordship may see,
Mumbai.
page 136.
So what is your value?
Is in one
40
this
lakh.
case,
40 lakhs is a good amount.
40 lakh, your lordship, nowadays with all due respect of getting an
We'll have the arbitration, yeah. Agreement may be there, but the arbitrator, if you point out here, it can be very well
Yes,
done.
madam. Yes, ma'am. That can be done, madam.
But apart from that, the question as to whether there was 3 kilometers or 6 kilometers, whether it was the nearest distance or not.
only that it should needs to be, if they can.
Why you are not filing an affidavit?
No, madam, may I allow to suggest, madam, one thing,
Huh?
madam? If, madam, they have, either a new.
But why you are not filing an affidavit? Which department you are?
The special, madam.
HPCL. Why? File an affidavit, take a cost of 50,000 and file an affidavit.
But it has been difficult for me, my lord, because, madam.
Why? You were engaged later.
But, my lord, the cost part, my lord.
Obviously.
Not 50.
Why haven't you filed?
My lord,
You are a public sector undertaking.
Yes, madam.
What is your problem in filing an affidavit?
But there is no problem, but, my lord,
We will
Madam,
take it that there is no denial on the ground of doctrine of non-traverse. We will direct you to pay this amount of 40 lakhs. You don't want to file an affidavit, we'll take it on record that you don't want to file an affidavit. Sure.
or my lord,
Let me write it down. Interest, how much?
no problem, my lord,
Interest,
I'll prefer 18%.
18%. How much?
Current bank rate.
Make it 7.5%.
But late day, my lord, file a representation, we consider, my lord.
Absolutely no. Why he will file a representation? Do you want this court to be a post box? Absolutely no.
Or, my lord,
This court matter has come up before this court. There is no doctrine, there is no denial to those aspects. So obviously we'll admit it.
at the same
That
time,
whatever has been
but at
stated
the
is
same time, I
there.
have to see, my lord, whether this petition is maintainable or not, my lord.
Why?
But, my lord, there is a clause or arbitration clause. my
So
lord.
what? We'll say
They have not
that
raised
it
any
violates his
arbitration,
right.
my lord.
It has violated his right under 19(1)(g). When there is a violation of a fundamental right, Whirlpool comes in.
But this plea was not raised by the petitioner, my lord.
Which one?
But that the action of the especially is an arbitrary one, my lord.
Not necessary. He has stated 100% legitimate expectation. Article 14 comes in. Don't worry.
But there is a specific clause of arbitration, my lord.
So what?
But I am
Article Whirlpool comes in.
But I
Then there is the other judgment, no?
But I MP
2000.
power project, my lord, which says, my lord, if there is a clause of arbitration, my lord, but it is not maintained, my lord. If I am.
Where is it? There is no judgment to that effect. So that cannot be a straitjacket formula that arbitration clause is there, it is not maintained. No.
What can I see, man?
It has to be decided on the facts of each case. Here is a case where my petition has been filed in 2020. You have not filed your reply. So under such circumstances, we'll take it that you have admitted the stand. You have admitted the stand. Forget about this. And apart from that, this arbitration clause will come when? How can you, when can you raise this arbitration clause?
There is a dispute, my lord.
No. The arbitration clause will be, you have to say, if we go by the Arbitration Act, you have to go as per Section 8. You have to tell this court that, look here, there's an arbitration clause. And as such, we also want, they have agreed to. There's no application to the effect.
But the clause, my lord,
And
specifically.
Section 5 cannot cannot under any means say that this court cannot exercise the jurisdiction. So don't worry. We them
But at
direct
the
to
same
pay
time,
this
can you see
40
that
lakh.
the clause specifically is there if there is a dispute?
There's no
my lord?
denial. Therefore, the instant repetition.
I pray, my lord, to give me 2 weeks time, my lord, I'll file a petition, my lord.
Cost?
less amount.
Oh, the cost is to be given. And what is the other matter with PWD?
Same issue.
And he has sought for time on many occasions earlier. Submits that the state are going to file an affidavit within 7 days from today. That is on 25/1/2022. And here, how many days you have taken?
I received some issue, but it is not viable matter to file an affidavit matter. But we seek some more instruction from my client.
They may also renew such prayer if the respondents do not intend to file any affidavit in opposition. So very well. It would be open to the learned counsel to renew the prayer after the pleadings are complete. So, are you filing affidavit or not?
Yes, madam. But by Monday, I'll file. By Monday, I'll file.
Monday?
Yes, madam.
Okay. The learned counsel appearing on behalf of the HPCL submits that he has received the instructions in the matter and he may granted an additional opportunity for filing their affidavits in both the petitions. This court have also duly taken note of that on the earlier occasion also, the respondent on behalf, the respondents, that is the HPCL, have sought for time for filing the affidavit. However, no such affidavit was filed. However, taking into account, for the ends of justice, this court grants an opportunity, an additional opportunity to file the affidavit by 15th of February 2024. List the matter again on 22nd of February. List the matter again on 28th of February 2024. The petitioner is to advise to be at liberty to file reply.
Your Lordship, can it be on 27?
27? Why?
28 hours.
First of all, you have not been able to show any legal issue. So under such circumstances, the question doesn't arise to have it on a Tuesday. Mr. Botago, here is a case where they are asking for money pending for the period from 2014 to 2016, filing a writ petition in the year 2019 and 20. Whether it is permissible, writ can be issued. A bar of limitation, can it be taken away?
It can't be, madam.
Then look into the judgment of ABL International and look into more particularly paragraph number 27. Can a writ be maintainable without a legal issue and only on a monetary claim? The Supreme Court categorically says that purely a monetary claim writ petition cannot be maintainable. It can only be done as a consequential relief. Take this ground.
Yes.
And the next occasion, we see the dismissal of the writ petition. Otherwise, it should be allowed.
Yeah.
If your minor kindly peruses the last order,
Yes.
an advertisement was to be prepared.
Submitted that the respondent authorities are taking steps, but on account of inadequacy of certain documents and advertisement to be issued to by the dealer, the state formalities could not be completed.
So this is regarding the reconstruction of the.
Yes, what does this matter?
But this is regarding the reconstitution of the retail outlet.
Oh, yes.
So the advertisement was in fact floated. There has been no objection till date. Yes. Now they are again required to submit some document which the process is ongoing between the petitioner and the IOC. So that is what I have been instructed.
Why should you keep the matter pending?
This up to
They are taking it, they are helping you out.
Yes,
So what remains in the petition?
we have filed a paper publication also, and till date there's been no objection. And we are
Understood. This is a question of reconstitution of the firm. Now, if this is a case of reconstitution, the respondents are helping you out. So under such a, where is the cause of action against them?
we are cooperating with them, and the matter is being taken by the petitioner also. We are helping them.
No. We close it. Our liberty, I'll give you later on. If you are agree. And you won't insist on the so-called notice. The so-called notice, in view of your actions now, the so-called notice has become redundant.
Yes.
The instant with petition has been filed by the petitioner challenging the show cause notice bearing number GDO/SCN/2341341/MOSPL dated 28/5/2020 issued by the Respondent Corporation, as well as the proceedings initiated by the Respondent Corporation against the petitioner for termination of the retail outlet dealership. This court had duly perused the various orders being passed by this court on earlier dates. And from the same, it reveals that the Respondent Corporation are the petitioner, it reveals that the petitioner as well as the Respondent Corporation are amicably trying to resolve the issue. So this court have also put a pointed query upon Mr. B. Bharadwaj, the learned counsel appearing on behalf of the Respondent Corporation, as to whether the Respondent Corporation would insist upon the the impugned show cause notice and the proceeding. The learned counsel submits that in view of the present status, the Respondent Corporation would not further like to go ahead with the said so-called proceedings. However, in the circumstance at a later stage, the negotiations between the petitioner as well as the Respondent Corporation fails. The Respondent Corporation would take such steps as otherwise envisaged in the law. Taking into account the above, this court therefore does not find any reasons for keeping the instant petition pending. More so, in view of the present stand of the Respondent Corporation. So accordingly, the petitions therefore stands disposed of, with the observation that the Respondent Corporation shall not act upon the said show cause impugned show cause notice dated 28/5/2020, as well as the proceedings initiated against the petitioner for termination of the retail outlet dealership. However, this court grants the liberty to the Respondent Corporation in the circumstance the negotiations fails to take such actions as otherwise envisaged in the law. I stop this thing.
There was an interim order. There was an interim order.
Now you are not acting upon, so nothing remains out there. So tomorrow, if nothing works, then you can very well. It is also observed that in the circumstance the respondents take fresh action against the petitioners will also be at liberty to approach this court.
There are some eyes.
I sense you.
God bless.
There's an order passed by an Lordship on the last.
Hmm.
My Lordship has taken up to dispose of the matter. with the grievances which they have met out. Number one is about the seventh floor. Seventh floor, they declared as to be irregular. We could not pay. Subsequently, entire they have been issued an NOC. Entire gone. NOC, whole building, NOC was issued, that was cancelled. Then, my lord, they have issued a so-called notice and that is pending, whichever reply. But the main issue was hotel in respect. That was sealed. Then your lordship had desealed because of my son's marriage. Thereafter, again, we tried to put a guest house where a trade license was granted 30 rooms, they have cancelled it. Now we applied for a trade license, but consider 50 rooms. We are not operating it till this is not been decided by this court.
No, question of deciding of this court does not arise. This court had made it clear that till the respondents do not issue the compounding or the regularization of the permission, nothing can be done.
Yeah, that's why I'm saying, my lord.
Unless somebody comes up before this court by filing a writ petition that this regularization application has not been taken into consideration.
Right. My lord, now,
What
my
do you
lord,
mean?
nothing
Yes,
remains-
madam.
Nothing remains a
You are the main person.
nothing remains a repetition, my lord.
No, remaining the block A and B.
Block A.
You are not concerned with block A and B. He's concerned.
Yes.
And he is concerned.
I have filed a writ petition now in terms of the NOC that was cancelled, saying that the NOC was granted to the entire property. The NOC was initially as a lordship.
Where is that writ petition?
That was listed, I think, 2 weeks back. The date is fixed for 15th or 16th for the government to file a reply. 2 writ petitions have been freshly filed. One by the set of the people who are staying in the block A. They are saying that because of the cancellation of the NOC, they stand today nowhere. My case is the fact that because the NOC was cancelled, the owner is not coming forward to apply. I have not been able to do it and the liability now comes on me. Stand taken by the government is by the department is that the NOC that was granted to initially to the builder. But since I could not perform my obligation because of certain financial difficulties, the responsibility went back to the owner. They say that because of this, there has been a transfer of the responsibility in terms of the NOC, and therefore the NOC is now no more what the NOC was given, and therefore it was cancelled. So I have now come to court to say, no, the NOC still stands. The development agreement is very well in existence, and I have constructed completely in terms of it. So that writ petition yet to be decided. I think the department will have to come back and give an explanation whether that NOC now stands valid or not. In his grievance, I think whatever he wanted, because of the division, there were 3 floors were considered to be illegal. There was a regulation order passed, but I think I could not comply because I was going through financial problem. Subsequently, the NOC was also cancelled. So that's the previous part. The writ petition.
So therefore, don't you think all the 3 writ petitions requires to be taken up together?
He is a flat owner. If he's got any grievance, he can obviously come and participate in the writ petitions which are pending. While this his grievance was if there's an irregularity, that the GMD and GMC is anyway in session, they can decide in terms of an affidavit that they filed, they've submitted a report also, saying that they are in session and want to decide whether the irregularity or regularity still exists or not. So that is within them.
No, understood, but the fact is, as of now, this is the writ petition. See the reliefs which have been sought for.
Yes.
Case 14.
Directing the official respondents number 1 and 2 to demolish the 7th floor of block A.
Yes.
You are not concerned. He is not concerned with block A.
No, mine is 7th floor, block A.
You are block A.
Yes.
And the entire block C. Block C is whose?
There were 3 blocks, A, B, C, constructed together. The violation was in Clause C because it's a residential area where the commercial establishment was going on. That now stands.
Where was the hotel?
The hotel was in C. C.
So C is okay. C has been was sealed. That portion was sealed.
Yes.
But he has asked for demolition of block A.
Right.
So block A, he is not there.
He
is not there in block A. You are in C.
No. There are 2. One is block A, 7th floor, I'm owning it. 7th floor. 7th floor.
Okay.
And block C is a hotel.
Okay.
Where I was running in a
But
residential
only
complex.
this court has only passed orders as regards block
C is concerned. Block C is
but not
concerned.
as regards A.
No, not your lordship was not that so far as 7th floor. His grievance was a 2-fold. One is 7th floor to demolish it. 7th floor where my
I am staying there, and block C is the hotel. Residential complex, I was owning a hotel. That is why your lordship has.
You were a lessee.
He had a house also.
No, the house is 7th floor.
Seventh.
That is different.
Yes.
Here he therefore
He was a lessee.
this question has to be adjudicated as to whether his this 7th floor is required to be demolished or not. That is that question remains out here. But as regards the hotel, you were a lessee.
Yes.
Lessee for how many years?
So I was there, my lord. I once. My affidavit I have to check. I think.
You were a lessee of another person.
The owner.
Owner.
The owner.
Yes.
So you were a lessee of the owner.
Yes.
Now who is the appearing for the owner?
Owner is not coming forward.
He appears for the.
No,
Huh? Owner is not a party.
He is a party, but nobody appears.
nobody appears. That's the whole problem.
Now you are the respondent. Who is Nirupama Rava?
The owner.
The owner has filed an affidavit in
Yes,
opposition.
but nobody is appearing after that. It's been
Who
some
is
time.
appearing? Sanjit Deka or something. Nirupama Rava has filed an affidavit.
Yes, yes, your
Now,
lordship. They have filed
therefore,
it.
that is respond number 9.
Yes.
So we have to take her stand in that regard. You are, what is your name, Mr. Das?
Mine is, my lord.
Nitya Ranjan Bokotogui.
Yes. And yes.
So your case is, no, you were a lessee only. If I remember, you were a lessee of that hotel. Now, how long was the lease agreement?
Yes.
Yes, madam, what do you have to say about the 7th floor? And have you regularized the block C? Have they filed any application for regularizing block C? Very well. And what about block A? And block A, 7th floor? What is your stand? Was it illegal? Illegal, then we apply the judgment of Priyanka Estates and demolish it. Where is the judgment? Supreme Court judgment is there. One has to, what is the word used? That one has to take it with an iron fist. Demolish this type of thing. Where is it? Yes, got it. 2010 to SCC, page 27. So what is your stand? 7th floor, are you demolishing it or not? If you are demolishing, we can close the requisition. Huh? Madam, kindly come here. We can't hear you.
My lord. Whether they have give the reply or to the effect or not, my lord.
Oh.
Petitioner, my lord.
What reply?
Against the notice, my lord, issued by the government, my lord.
Why will the petitioner reply? The petitioner wants that the 7th floor be demolished or blockade. It is you who have to take an action. What action have you taken? Whether it is legal or illegal. That's it. Why is it taking so much of time on the part of the GMD authority?
Here we have filed, my lord, affidavit, my lord, it has not been mentioned anywhere, my lord. Why we have not taken, my lord. Maybe take up after day after tomorrow, my lord, I will take instruction.
We have replied, their scopers we have replied. But they have to take an action. This way or that way, they have to reply back to us.
Who?
They have given a scopers to us in respect of 7th floor. We have given a reply. We are waiting for them.
You mean who, the owner has to give a-
7 4.
You have given a
Yes.
reply. Has the reply been brought on record?
Yes, that reply, my lord. It is, I think they brought it in record
Mr. Das, why don't you bring on record that aspect of the matter
of the reply.
of they issuing a show cause and then, yeah. Then if the authorities are doing their job, why should this court keep on keeping this matter pending out here?
I think that reply is there, man.
You have replied and that GMDA is sitting tight.
Yes, that's the.
Oh,
They have to give response to us.
yeah.
Suppose they said illegal.
You want the hearing, do something out there. Madam, not ready? Eh?
Madam, day after tomorrow.
Right? Is this matter parted?
No, my lord.
Huh? Not parted.
No, parted.
Parted দেখাইছে নি? Not parted. We do one thing. List this matter along with that petition.
Yeah, truly, I just be clear.
Because that will help the court, whoever it's taking.
Yes, now since the entire NOC is under question, GMD will also have to reply to that, the authorities will have to reply whether the NOC is permissible or not. If it is done, then the violation may not come to effect.
Therefore,
Yes.
see, the subject matter of your petition, if it is allowed, then obviously this order you can't be passed here.
Yes.
So under this petition should be taken along with that.
Yes.
Shall be dealt with
Yes.
it. Mr. R.B. Phukan.
But block C is concerned, that particular party is, I think that's over, block C. Only remain block 7.
No,
But
whatever
Lordship-
mean, Black Sea also is there.
No, C.
Have you sought for regularization?
We sought for.
I can't, they will have to see because,
No, he is only a lessee. The owner has to sort for, the owner has not done it.
yes, owner has not done anything.
So under such circumstances, if the regularization has not been sought for, they cannot use it. There's no way
In fact,
using
what
it.
has been told to me is that the hotel is the guest house is also.
You
not
see,
done.
I have given the liberty to all the authorities to do. Let the authority take a call. I have not said, but till the authority does not regularize, he cannot use it as a commercial unit.
My lord, we are not operating also because we know the authority has to do it now.
No, therefore, if the petitioner or the owner is not doing it, you can't help it. You have to file a civil suit against the owner in violation of your rights, whatever may be. Mr. R.B. Phukan, the learned counsel appearing on behalf of the respondent number 8, submits that there are two analogous petitions, two connected petitions which have been filed. One of such one being WPC number
I just give you a lot.
so and so, filed by the respondent number 8, challenging certain actions on the part of the GMD authorities, and the other being the residents of the flats in question, challenging the actions of the GMDA authorities in cancellation of the NOC. It is the opinion of this court that the outcome of the said two petition will have an impact on the present petition. And as such, this court directs the instant petition to be listed along with the said two petitions being so and so and so and so.
7008
on 4th of March 2024.
My lord, there is one report. The lordship about the 7-4, they have filed an affidavit. An affidavit filed by the authority, that is GMD on inquiry report. In inquiry report, last portion they have written, the addition of 7-4 of block A, Assam type of area is compoundable from FAR point of view. But it is to be examined. From the point of
This is a
setback.
long time. I've read that. It
Yes,
is a
your
long
lordship, I
time.
read that, that's why, yes.
See, the GMDA person is not, they don't know anything. Can't help it.
But they have to take an action on the.
No, that is why those two petitions,
That's more
once
important. That's more
once
important.
those two petitions come, this court can take it.
Yes.
Now the learned counsel for the petitioner has taken the role of an amicus. He's not saying anything. Yes, Nick. 19. I'm fixing it on 4th.
Yes.
Yes, Mr. Raj.
It's regard to diversion of a natural flow drain lots. The one drain has been diverted illegally, and thereafter the petitioner approached the authority, and one order was passed to keep the natural flow out. Based on the report by the executive engineer PWD lots. And that has been silenced by the private respondent before this honorable court, and that this honorable court was pleased to grant some time to raise their grievance lots. But now they are sitting over the direction also.
Wait. Let me get to know what was the facts?
The fact is that Lordship, may come to page 26. There's a diagram. It is will be clear to you, Lordship.
You mean the matter went out from here? Yes, tell me.
Page 26, Lordship. There's a diagram showing the existing canal, and one is convenient path for canal. That is the natural way, Lordship.
Okay.
And that canal has been diverted, Lordship. Existing.
Oh,
canal.
by this other one.
Yes, Lordship.
Okay, now who are
Now
you?
that there is a order to.
Who are you?
I'm the resident there, Lordship.
Which one? Resident of which part?
Resident of this part also. The private land shown in the left side of the canal, existing canal.
Left side of the canal or the
Left side,
right
private
side?
private lane.
But there are two private lanes one down below and on top.
Down below, Lordship.
Down below. Okay. But that is the natural way.
No, that is not a natural way. Natural is the straight one, Lordship. The convenient convenient path for canal.
You see, this way to the canal will go. There's no way out because if you see the direction of the arrow, it is going from the paver block road.
And that has been diverted, Lordship. The existing canal.
And thereby it is touching on the northern portion.
Yes, Lordship.
Which you are agreed.
Yes, Lordship. And some of the other residents are also agreed, Lordship. Because the erosions are taking place, the high tension wearings are in danger here, Lordship. And the authority passed an order to make it straight, Lordship. That is the natural flow.
Then what happened?
Then the private respondent approached this honorable court, challenging that order, Lordship, and that liberty was given to the private respondent to raise their grievance within a time frame, Lordship. They set over the direction, Lordship.
Who?
The private respondents. To approach again before the district commissioner, then the deputy commissioner.
So then what has happened?
Thereafter, Lordship was pleased to call for the current status of the proceeding. After they are given the liberty to approach the district authority again.
Okay. So you mean to say that this road was going and it was supposed to go straight?
Straight.
Then it was made it left by the private respondent.
Lordship.
And the authorities have interfered.
Yes, Lordship.
And for which they put a challenge.
Yes, Lordship.
And there was a stay.
No stay, Lordship.
There was no stay. The authorities wanted to interfere. Did not interfere.
No, because of the proceeding filed by
now the thing is, although they approached, the private respondents approached this court, but thereupon they have not done anything, but the authorities are sitting tight over.
Yes.
That's your case.
Yes.
Why are you sitting tight?
Lordship, this is the order.
Who is appearing for the private respondent?
They are not appearing.
We have taken service both by registered post and a dusty also, Lordship. But they are not approaching.
They have not come. Service is complete.
Service is complete.
Then why are you not taking action?
My lord, they initially my instruction is, my lord, as per the direction of this honorable court, my lord, the hearing was to be conducted from hearing both the sides, they and the private respondent. They appeared initially, my lord. Then
so they have initiated some procedure.
Yes.
Then what happened?
Hearing was scheduled, my lord. Then some of them appeared through counsel and some.
What have you done to that procedure?
That lordship last it was the notice was issued to them for
hearing that the notice was issued on 12th of January, fixing
2023 or
2021 itself.
12th of January 2021.
21.
Then what are you doing? If they don't appear, you
Can we
stick to your decision. Well, what is the proceedings number?
The notice,
If they don't appear, forget about them. It is their lookout. Fix a date. And have they appeared thereafter?
thereafter, I do not have exact.
You can't keep this matter pending like this. You'll have serious consequences.
Only the copy of the notice I have.
What is the number?
Number of notice.
No, case number.
No, there is no case number. Case number. This is the notice.
Therefore, the petitioners hearing are aggrieved by the inaction on the part of the respondent authorities in not giving effect to the order dated 4/6/2020, whereby it was decided that the existing canal would be allowed to proceed in terms with the convenient path for canal, rather than the path the private respondents have made. In as much as the path which the private respondents have made, thereby diverting the canal, have led to the erosion of the private lands of the petitioners and others. It reveals from the records that the respondent authorities had duly passed an order on 4/6/2020 directing diversion of the course of the public drain as per its natural flow. This order, however, was put to challenge by the private respondents in WPC number 3133/2020 before this court. By an order dated 18/8/2020, this court, on the ground that the principles of natural justice was not adhered to, granted liberty to the private respondents who were the petitioners to apply for modification of alteration of vacation of the order dated 4/6/2020 before the competent authority, and further directed that the said representation be submitted within a period of 3 weeks from the date of the from 18/8/2020, and to be considered on merit and disposed of by a speaking order after hearing all stakeholders, including the private respondents who were the writ petitioners therein. It was also mentioned that until the said exercise is not completed, the operation of the impugned order dated 4/6/2020 shall remain suspended. Today, Mr. B.J. Talukdar, the learned counsel senior counsel appearing on behalf of the district administration, had submitted that the private respondents had duly submitted a representation.
After the period was over.
However, after the period of 3 weeks as directed by this court, Be that as it may, the respondent authorities have duly were considering the said aspect. And the last of such notice was issued
On 12/1/2021.
2021. However, none of the private respondents appeared.
Some they appear.
Some of the private respondents appeared, whereas the others did not. Now tell me, how many representations were filed?
Two numbers of the petitioner, so and so. Submitted two numbers of the petitioner initially. Saifuddin Akanda and Rosana E. Khanam submitted declaration, Lordship. I have to.
No, it's okay. So who has filed? Saifuddin Akanda and Rosana, come on.
Rosana E. Khanam.
Others did not file.
My.
Huh?
Yes, ma'am.
It has also been submitted that out of the private respondents, number 8 to 15, only the private respondent number 11 and 12 had filed their representations. Be it as it may, it is the opinion of this court that the respondent authorities cannot delay the disposal of the said proceedings for an indefinite period. From the record itself, it reveals that more than 3.5 years have already passed by. It is also seen that the respondent district administration have not taken further steps after 12/1/2021. Under such circumstances, this court therefore directs the district administration, more particularly who is taking up DC.
It has come, additional deputy commissioner.
The district commissioner, Kamrup Metro,
Gwalpara.
and the Gwalpara, either by himself or through his delegate, take urgent steps for disposal of the said proceedings. This court fixes the matter again on 18th of March 2018, 20th of March 2024, on which date Mr. B.J. Talukdar, the learned counsel, appearing on behalf of the respondent district administration, shall apprise this court as to whether any decision has been taken in respect to the order dated 4/6/2020 by the respondent authorities. List according.
Lordship, can it be little earlier, Lordship? Our anxiety is that road in that particular area covering the existing canal is sanctioned. Once the construction of road is over, then it might be difficult to execute the order.
Hearing, Lordship.
Mr. Counsel, all this while, you did not get any good order. Understood? Today, if I direct them to do it here, then they will not be able to pass them. This court, however, this court further directs the district administration to take appropriate steps so that the said proceedings can be disposed of preferably before, so that the said proceeding initiated at the behest of the private respondents can be disposed of on or before, prior to the next date fixed by this court so that the same can be placed before this.
That's deeply honest.
If they don't cooperate, my lord, if they don't come for hearing.
Don't come, you do it, whatever you know what is to be done. The requirement is there, all these things required. Yeah, next. Hey, Chiku Sulana requirement. Yes.
May I please, Your Lordship?
Mm.
Lordship, matter pertains to non-payment of contractual outstanding bills, Your Lordship.
How much?
More than, Lordship, 59,34,807, Lordship.
Yes, government, what is your stand?
Let's say we have not received any instruction, but let's say otherwise, kindly give a direction to the.
Verify and pay,
Verify.
8 months, dispose.
Lordship, interest part may be considered, Lordship. We have also.
Cancel. Order, we are not passing that. Sending you to the civil court. Go there.
And
Verify and pay. Right.
oblige.
Thank you.
Yes, Mr. Mahmood.
My lord, on the last occasion, your lordship directed us to file affidavits annexing the judgment and decree that
Of
we have
which
filed.
one?
Yes, that may be seen at page 38.
Page 38.
Now kindly see 36.
38.
36.
36.
This is your
is what?
lordship's order.
Huh? When did you file affidavit?
Yes, it is filed on 4/12/23.
No, that affidavit is not common.
I don't have a copy of.
Copy,
Huh?
we have not received.
Nobody has received, that is not someone record.
Without serving notice how it has come.
Huh?
May I see the record, how it got served?
What kind of my.
Without serving notice opposite party, affidavit cannot be filed. Registry do not allow.
That is why.
Yes.
If you have filed in the month of December, it is not on record also. So the registry did not allow you. The answer is very simple.
That will get short, very short, that mechanism. And I will serve copy upon them and file.
Mr. M.U. Mahmood, the learned counsel appearing on behalf of the petitioner submits that the affidavit has been filed on
4/12/23.
4/12/2023.
Yes.
However, the learned counsel appearing on behalf of the respondents asserts that no copy of such affidavit have been furnished. First, it is also seen that the said affidavit is not a part of the instant of the record. So taking into account the above, list the matter again on 1st of March 2024, on which date the petitioner shall take on or before which date the petitioner shall take appropriate steps so that the affidavit is on record.
All right.
Yes, you didn't have a case then, so you sought for an adjournment.
Premium has been paid
To what?
already, my lord.
Premium
In the
for
year
what?
2001 itself.
Premium for what?
Premium for that allotment of that land, my lord.
You paid the land premium after the period,
No, 2001 itself.
but you paid the premium after the date.
79 sale deed was there, my lord. 73, my lord, register sale deed. Thereafter, name also reflected in the papers also, my lord.
Then What is the name of the petitioner?
Myself, my lord. Mrs.
You filed an application before the Board of Revenue.
Yes, my lord.
For what?
For my
67.
lord, against the order of the my lord settlement officer, my lord.
For what?
For my lord, because without hearing us, my lord, they have my lord deleted our names, my lord, from the records, and thereafter, my lord, incorporated the name of the original pattada. Against the said order, we filed appeal before the revenue board, my lord. And revenue board, my lord, there was delay also, my lord. That delay has been condoned, and case was proceeded, my lord. In that case, my lord, I have seen that, my lord, after it is ready for hearing, my lord, 2-3 days thereafter, it was, my lord, finally disposed of, my lord.
Oh, I remember.
That was the case, my
The
lord.
records are against you.
Yes, my lord.
Yes.
Yes, my lord.
You have sought for time.
Yes, my lord.
On that very day, your lawyer was very present, and you submitted on last occasion out here that you were not heard and you were not heard. I remember.
I have checked up the records, my lord.
And you took a photograph then. This is the matter?
That was
Yes, I remember. So,
I have checked up the records, my lord.
the records are clear.
Here, my lord, only it was first.
Why should this court interfere?
No, on the first day of the hearing, my lord. First day of the hearing, matter was adjourned due to lockdown. And the second day, my lord, Planet Counsel for the engaged counsel for the appellant side, my lord, submitted one representation application, my lord, to adjourn the matter. Only next date fixed, my lord, case was, my lord, ex parte order. Because as we did not appear.
So on that day, your counsel was very much present.
17, there is a date 17/9, my lord.
So that day,
17/11.
your counsel was very present. I remember that the counsel who was there was H.K. Decker.
Kindly peruse your lordship the records of the appeal.
This is the appeal.
Appeal memo, my lord. Because condonation also there, my lord.
Yes. Condonation is okay, but where is the other one? Yes. Yes, the advocate for the counsel present 17/11.
Yes.
17/11.
Yes, my lord.
On behalf of the senior advocate, he had given a submission that the senior advocate is not able to appear as he is advised not to come due to COVID. The counsel who appeared, Mr. Sodri, gave an application that has not been filed by Wakalatama. He is asked to file his Wakalatama by the end of the day if his petition for adjournment is to be accepted. The counsel who appeared also agreed to plead to the case. The respondent also not appeared without notice, not appeared without notice. Government, the last date is given to both the parties to give their final submissions refix on it. Later on, the respondent number 13 appeared. Appellant absent on 22. The next day, the order was not passed.
Not passed.
Appellant absent, though last date was given for submission of so and so. Government advocate said the appellant being absent without taking steps and is wasted the court's time and counsel for the respondent. This is accepted. Case brief is that the appellant prepared the appeal against the order of the ADC. We have passed the variety case, heard the respondent's argument in detail, and the records placed before this court. The case is reserved for judgment.
That is
what is wrong?
That is only, my lord. So one opportunity may be given, my lord, so that petitioner, my lord, engaging any counsel can represent his case, my lord, before the review. Because in the settlement officer, before the settlement officer also order was ex parte.
This is not ex parte.
Yes, my lord, that is there.
In this case, at the Board of Revenue is not ex parte.
Board of Revenue, yes, my lord, that is order judgment, kindly peruse your lordship, that is mentioned.
So you have to show, therefore, that the order is wrong.
Yes, my lord.
Show me.
Because, my lord,
because your submission on the last occasion was only to that effect that we were not given, we did not know the date.
Yes.
Then I showed you the records. Yes.
Yes, my lord.
So now tell me why the order is wrong.
Because order is wrong because, my lord, grounds, my lord, ground 69, yes.
Yes, you purchase the land.
Yes.
What land?
My lord, this priority, by way of priority.
Where?
Lordship,
Land where?
Boragao, my lord, Sim Boragao.
For that, do you require, when did you purchase?
In the year 1973, my lord. 73.
Sale
Yes.
deed.
Yes, my lord. Sale deed is 79. I have annexed here.
You purchased it on 7/6/1982.
First one is 73.
You
Page-
purchased when?
Yes, my lord. First one, page 35, original copy. Last page is, my lord, that is 18/4/73. Page 37.
Huh?
Page 37.
What right did you purchase? Did they acquire the acquisition rights at that point of time? Occupancy, did they have the ownership rights in 1972?
Yes, my lord. Kasa Hotian is, yes.
Did these people have the ownership rights in terms of 25 of the 71 Act or 23 of the 71 Act? These were your owners.
Yes, my lord.
They had. Where is it?
Only by way of Rati Hotian.
Right Khatian cannot be sold.
Yes, my lord. Only this, that much.
Then how do you get your right?
My lord, on the basis of
How
the,
can there be a sale deed in respect to a property where you are not the owner?
in Sita and Jawanbadi also names.
Forget about the Sita and Javamadi. These are mutation records.
Yes, my lord.
Tell me, how do you get your right on the basis of a sale deed?
As it is evident in the records, my lord, by way of the, as he was agriculture is there, my tenant there. Subsequently, after 16 years.
I am asking you, the Act categorically mentions that there is a manner in which an occupancy tenant can get a right of ownership. Did the owner from whom you have purchased, did your vendor get that right under the provisions of section 23 or 25 of the Act of 1971? That is my simple question. If he does not have the right, matter ends there. The sale deed becomes useless. What are these documents you are placing?
One is premium paid, my lord.
Premium for what?
For that plot of land, my lord.
Premium for what?
For the plot of land, the premium also paid, my lord. As I have
What
seen.
premium?
Yes, this one.
What premium has been paid? These are called khotiar, dokhal bosor.
Yes.
28 bosor.
Yes,
So this is all dokhal.
yes, my lord.
They are dokhal ka.
Yes. Only possession.
So possession. So do you have a right to remain out there on the basis of possession?
But in the premium premium paid letter, that is there, my lord.
What?
Dolbhukta kora hol. That is there.
Whatever may be, they made a mistake out there. You can, these are all wrongly which have been done, but the fact is, what right you have? Although this court do not agree to the revenue board's assertion to the effect that you did not take any permission from the owner. You sold this without prior permission of the deputy commissioner or the knowledge of the Pattada. Now, in view of the 1971 Act, you cannot part with your possession without taking the permission from the deputy commissioner.
That is rejected, appears to be rejected in the, that Jawanbandi copy and Sita copy, that is in the column, comment column that is mentioned.
What?
That objection is rejected.
What about the other victim? But I am saying as per law, can you transfer the right over the property, the khatiyan right, to another person You can't. You are to inform the deputy commissioner about these aspects, and the deputy commissioner may then issue a khatiyan to somebody else.
Yes, my
This
lord.
is the law.
Only the authority is the deputy commissioner.
Then, without doing anything, you sold it, and now you become the
I have
owner.
not sold it. I have purchased it.
So ask the money back from these people.
We are in the
You paid
possession.
how much? 200 rupees for 6 bighas of land.
Not-
Huh? How much did you pay? See, you sold it. How much? It is there. Hey, 2,000 rupees for 2 bighas, 2 katha, 18 letter. Get back the 2,000 rupees.
And next one, another is also there, my lord. Next, another page, my lord. Shelby was here.
Okay.
Subject to lordship confidence. I have nothing to say.
We'll have it on 12 for dismissal. List the matter again on 12.
In the meantime, I'll file additional affidavit also, my lord. Placing that.
File whatever.
Yes.
You would like to see. On 20, on which date an attempt shall be made to dispose of it.
Relax, my lord.
May I please, Your Honor?
Yeah.
My lord, this matter is relates to acquisition of land, my lord. Kindly see the order dated 22/1/2024, my lord.
Oh, yes. Your land, part of it.
Yes.
Yes. Yes.
Lordship must have perused that letter dated
Absolutely.
6/24. I am also seeing such a petition first time now. The contractor has accepted to and agreed to pay the land compensation.
No, land compensation at government value. He has, so it has to be as per your mala.
No, so far
As
as
per your mala scheme, there's no other way.
Assam.
You are not, mala scheme is a scheme by which you can go outside the land acquisition proceedings.
Once the land is demarcated, Lordship, once their right is established, then the contractor will pay. But the contractor is not a party.
Don't worry. We ask them not to do anything. We make this order absolute. Don't construct.
Let the government.
We are not concerned. You being in the contractor, he is not bothered with the contractor. Why should he make the contractor a party? It is your responsibility when you are
I'm
taking the
submitting,
land.
Lordship, let this letter come into record, Lordship.
I am not going to keep these type of letters also on record.
No.
This is very strange thing which these people have
Yes,
done.
yes.
What type of letters are these?
No, in fact, this has not been communicated to me even, Lordship.
It has been communicated by the circle officer, additional deputy commissioner. And it's a
No,
letter.
there's a, this is based upon certain instructions being issued by the, by the
Yes, Lordship,
executive
on-
engineer. Kindly come to the last
On
page.
14/11/2023, one letter was written by the executive engineer to the addition.
Kindly see page 27 of those documents.
Yes. 6 to
This is being written by the executive engineer
Yes,
to the additional, and on the basis of that, the additional deputy commissioner has written.
yes.
The land demarcation proceedings have already been done. The contractor does not like the land demarcation proceedings. Who is he? The district administration, the revenue department have already done it, and now the contractor does not like it. See the tenor of the letter at page 27. Although the circular has submitted the land demarcation trace map and the valuation report for the mentioned land through so and so, we have raised reservation regarding the land demarcation process. It was intimated by the higher authority that there is no provision for land acquisition in so and so. Therefore, the contractor hereby accepts to pay the compensation as per the government valuation for the land used for construction area. The contractor requests to re-verify the land demarcated process. Once again, as the contractor has some reservation regarding the demarcation. What? Contractor has the, when the revenue authorities have already done it, what remains? And you may be allowed to construct.
No, I am not, what I am submitting, Lordship, let one affidavit be filed, Lordship. If the
Right.
other side any objection, Lordship, because so far as this line is concerned, Lordship, contractor requested to re-verify the land, Lord. That requires certain clarifications, Lordship. What kind of verification?
From whom? Can the contractor today say that I don't like the land demarcation made by the circle officer?
No, it may not be exact, reproduction of the, exact reflection of the
Well,
situation.
two authorities, right? One is the executive engineer and the other is also the addition, and the district commissioner also writes the same.
This is quite, I never went through such kind of situation. It is new for me even though.
And I'm shocked as to how he can say that I'm only going to pay as per the government valuation. You can't. It is if you don't go for acquisition, it has to be an outright sale. Outright sale will depend upon whatever valuation. So you need to have to more pump in into the revised estimate.
Yes.
And if you don't pump in, don't construct.
PMGS.
Today, Mrs. S. Bolwa, appearing on behalf of the district administration, had submitted an instruction dated 6/2/2024, wherein it has been mentioned that the circle officer had made the demarcation of the land and prepared the trace map and as well as the valuation report. It has also been mentioned that the executive engineer Borpeta, Mondia and Senga Territorial Road Division had some objection over the said demarcation on the ground that the contractor also had objection. It is also mentioned that as per the PMGSY scheme, the land in question cannot be acquisitioned. And as such, it has been mentioned by the executive engineer, concerned executive engineer, that the said land has to be, would be purchased by the contract, would be and as such, the contractor would pay the compensation to the persons affected as per the government land valuation. So it was also mentioned that as the contractor has already agreed to pay the compensation, this court may be requested to allow to resume the remaining construction works. The said instruction, along with the other documents, are collectively kept on record and marked with the letter A. Next. It is astonishing to note that when the circle officer of the concerned division have already made the demarcation and have prepared the land value estimate, land value estimate, and the face map, the contractor have raised objection to the same, and in that regard have conveyed it through the concerned executive engineer, that the payment of compensation would be made once there is a fresh demarcation proceedings. This court also finds it very pertinent to observe that this court, however, finds it very pertinent to observe that as per the demarcation proceedings, the land of the petitioner falls within the ambit of the construction as from the demarcation proceeding. It appears that the land of the petitioner is included wherein the construction is being carried out. It's carried out. It is the opinion of this court that without acquiring the said land as per the without acquisition of the property of the petitioner in the manner envisaged in the law, the respondent authorities cannot carry out any construction activities over the same. Under such circumstances, this court is not inclined to permit resumption of construction works till the respondent authorities settle the dues with the petitioner. By paying the necessary compensation as per law. The matter stands adjourned to be listed again on 22nd of March 2022-24 for an approval.
Most of it.
The petitioner is agreeable to the amount as per government valuation law. I believe this court should not interfere whether.
Am I saying no to? I'm not taking anything.
Lots of use that word as per law, compensation as per law.
The payment has to. I'm not saying compensation as per law. It may. Therefore, the word is. I have not said acquiring.
Yeah.
Acquisition of the rights as per law. You may purchase it. You may give less than also the government value. I'm not saying on that. I'm not touched on the government value. Therefore, it has to be as per law.
Most of it.
25.
I can add one word. It is, however, open to the petitioner as well as the respondent authorities to arrive at an amicable solution into the matter.
Most of it.
Yes.
This petition can be disposed of. The petitioner before Lordship is a catering contractor in the railways. They challenged earlier in this petition the enhancement in the license fee. And there was an interim order also. And during the pendency of the petition, my lord, they have reassessed. Our ground was that there was no reassessment of same, and they have enhanced the license fee. Now, during the pendency of the petition, my lord, they have reassessed and they have passed fresh demand notice. That we have challenged before the Calcutta High Court, single judge, and that was dismissed. And then we have filed a writ appeal that is pending now.
So nothing you mean?
Some others, similar contrary, they filed a writ petition challenging that before this court, and this court has passed an interim protection, and those are pending. So in view of that, my lord,
No. These demand notice which are there.
My lord.
These demand notice now they no longer exist.
Possibly, but in the order which they have passed now, issuing fresh demand notice on the basis of reassessment of sale, doesn't refer to the impugned notice in this petitions. That is for the only anxiety. So I pray, my lord, possibly the lordship can close this petition, but with the observation possibly that without prejudice to my right to challenge the present notice.
That is a subsequent cause of action.
Subsequent otherwise.
I have nothing to do with that.
But then
that
there
will
is
be court number, other court who is taking 24, 25.
No, in this petition, my lord, while your lordship closes this petition.
No, this is not, you see, the subject matter of these as to whether these demand notices as on date survive.
For the higher citizen, notices are issued by the higher citizen.
Yes, Mr. Saivla, does these demand notice as on date survive?
Yes. Well, actually, we have, my lord, they were allowed to file a representation, my lord, and to submit those documents, my lord, the balance sheet and others. And after considering that they passed an order, I have filed an additional affidavit, my lord, just your lordship to see, my lord.
When?
On 37/21.
Then
37/21, this is the order passed, my lord. They have to challenge this order, my lord.
10th of August.
22nd of July 21.
So waiving of the amount of 50 in the terms of this is it.
Yes, my lord. Requesting for waiver now. Yes.
So on the basis thereof, again you have issued demand notice. Have you issued?
Sorry, my lord. That information is not with me, my lord.
Mr. S. G. N. Sahiwala, the learned counsel appearing on behalf of the IRTC, shall apprise this court on the next day as to whether pursuant to the order dated 22/7/2021 passed by the IRCTC, whether fresh demand notices have been issued. So he shall also obtain instruction as to whether the demand notices which have been impugned in the instant proceedings survive.
This is one demand, possibly I don't know whether they are aware of it.
We'll see it. This is the matter again on 13th of March.
13th of March, all right. May I please, Lordship? Lordship, in the
26 infractor.
Infractor, my lord.
Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that the petition has become infractor, and accordingly he may be permitted to withdraw the, and as such he would not like to further proceed with the instant writ. So accordingly, the said petition therefore stands closed as it has become infractor. Interim order, if any, stands vacated. Now 27 and 28.
Lordship, I prefer some short adjournment.
Yes.
Short adjournment.
Well, for why? Why?
Lordship, Lordship, in fact, this case, my lord, the affidavit of state as well as private respondent not yet filed, my lord.
They are not asking for time. Why you are asking for time?
Lordship, in this case, actually, Mr. Ken Chaudhary is engaged by the.
I don't engage.
That's right.
I don't consider that way. Now tell me, you have difficulty, eye infection, something to the effect.
I told you. Lordship, affidavit from state is required, my lord, in this case.
That the state doesn't want to file, we will take it. on the ground of non-preverse.
Original records are with me.
He is very happy.
Lordship,
He doesn't want to file.
the record is fine, my lord. Affidavit, because we are challenging our rejection, my lord.
Rejection of what?
Our tender, my lord. In
Tender matter.
Lordship.
Hey, continue.
Lordship, in fact, this is the third round of litigation, my lord.
Let us make it a fourth. Wait. Yes, what are your matters? Interim orders are there.
Lordship.
Yes. What are these tenders for?
Lordship, we are challenging here, my lord, at page 65, speaking order. My lord.
What is this tender for?
Lordship, tender for settle grant of minor mineral concession contract, my lord.
Then?
Lordship, and earlier initially rejected, and then we challenged, my lord. Court directed the authority to verify the hard copy, and we submitted there, and they even not bother to accept the court direction and accordingly rejected. Thereafter again challenged, and then they again rejected our order. Technical meeting.
Where is the rejection order?
Lordship will find at page 165.
150?
Lordship, 165. Yes.
155?
165.
65.
Yes.
165. Speaking order, 8th of February.
Yes.
Yes, what is the ground of your rejection?
Lordship will find at 168 minute. Point number 2 minute.
You are Ajit Borua.
Yes.
Ajit Borua. In the case, it is found that a document of fixation of the court fee stamp bears option number 5 instead of option number 4 for different claims, and also they fail to furnish signed copies of the original bidding document for participation in online auction.
Yes.
Public along with the bid. Secondly, he failed to sign the original bid document and submit it. The same is online as well as in the physical submission date. Submit the same on. Therefore, the bid cannot. So you did not submit.
Lordship, submit. Initially, their ground of rejection was that the affidavit which was required, that was not in the
proper format.
No, Miller. That was not submitted. Lordship will find that is first rejection, Miller.
No, now let us stick to this.
Lordship,
the last one.
Initially, there is ground of rejection was that I did not submitted the affidavit, Miller, and court fee. Later on, they taken another ground that my court fee is bear option 5 instead of option 4.
So, court fee, where is the bearing of bear stamp?
Lordship will find the page.
Now, how does it make a reference, relevance? Is it mentioned in the tender document that it has to be?
No, Miller.
That the court fee is for that.
For 100 rupee court fee is required to file, Miller.
So that you have filed?
Yes, Miller.
So they
Lordship will
have
find that
got
page.
the money?
Yes, Miller.
How is it relevant?
They make it relevant, Miller.
They make it relevant. Okay. Then
Lordship will find at page 115, Miller. My court fee.
No, it's 115.
Yes. This is the court fee.
Picking up court fee. Then what happened?
Initial rejection was that this court fee was not
option number 5.
Yes, Miller.
Bears option number 5.
Yes.
So how does it make a relevant?
Lordship, that has to be justified by.
Now, are you using this court fee for option number 5?
Lordship, actually, I was the participant of 2 bid, Miller. And another bid, Lordship will find at base 170, Miller. This is auction 5, Miller.
Okay.
It was.
So you given 2 separate things.
Lordship.
How does it matter anyway? That is
and another ground of rejection is there.
Now show me in the tender conditions about the court fee. Does it say that it has to be specific to that auction?
No, well, Lordship will find at page 52 that the eligibility.
Page 52.
52. Clause 5 million. That is the eligibility general criteria.
Where?
Lordship 1, 2, 4, 5.
Unauthorized affidavit on 100 rupees non-judicial paper declaring the lease for the major area. Where is the court fee business?
Lordship, next page 53.
Court fee stamp of AR shall be pasted and cancelled on the format available on the website. And then be cross-scanned and signed and uploaded in the website. What is the format?
That is the format, Miller.
Where is the format?
Format at page 115, Miller.
115. So there the format always also says auction 5.
That is the downloaded format. Perhaps there is a inadvertent mistake regarding mentioning of auction 4.
Whose mistake?
That is.
Is it kept blank 4 or 5?
No, Miller.
But anyways, this is a question of getting revenue. Then now let us come to the other one.
Other one is lawsuitable.
No. There only. The next condition.
Next condition is
to furnish signed copies of the original bidding document for participation in online auction.
Lordship will find my bid at page 79 to 10129 Miller. 79 to 129. This is the complete bid downloaded from their site.
Website.
Lordship will kindly see the down below, Miller. That is digitally signed and time of sign as well as time of submission, Miller.
4/7/2021.
Yes, Miller.
Then
and up to 129 Miller.
They failed to furnish signed copies of the original.
All papers were signed, Miller.
These were all digitally signed.
Digitally signed along with manual signature.
Now let us see what is required.
There is in the tender document, there is no requirement for signing, Miller, except bid document, Miller. Lordship will find at page Lordship at page 68, Miller. 68.
68.
8. This is for clause 18B. Bid letter, instruction for submission of bid letter.
Bid letter must be printed on the letterhead or near. The letter must be signed by a duly authorized representative of the bidder. In case the bidder is a company, in other cases, the bidder must personally sign the bid letter.
Yes. Only bid letter.
So you have signed the bid
Yes.
letter.
Yes.
Very well. Secondly, he failed to sign the original bid document and submit the same in online as well as, but it is incorrect.
Incorrect.
Therefore, the bid of Ojit Borga cannot be accepted. Now, what is the other petition? That is for another auction.
Lordship, same auction, Miller.
Both of you are fighting.
Lordship. Lordship, another thing is that, Miller, though we have been illegally rejected, Miller, there is a condition that, and there are total 10 tender. 7 have either withdrawn or rejected. We remain 3. Me, my friend's second petition, and my senior's time, Miller.
So you want to bring the CVC?
No, Miller.
Then?
Lordship, though where we have been rejected illegally, then only remain there remain 1 tender, Miller.
Both of you have been rejected.
Rejected, Miller. In that case, as per tender document, he has to go for fresh tender.
Show me.
Clause 8, Miller. (56)
55.
56, Miller. C. Only those bidder who are found to be eligible in accordance with terms and conditions of eligibility specified above in clause 5 with valid supporting document as stated above and whose initial price offer is equal to or greater than the reserve price referred to the technically qualified bidder shall be considered for second round of e-auction. Now important next B. The highest initial bidder offer against the technically qualified bidder shall be the floor price for second round of online electronic auction. Normally, if there are less than 2 technically qualified bidder, then the auction process shall be annulled and such technically qualified bidder, if any, would not get a chance to proceed to the second round of e-auction. However, if the auction is annulled on 2 occasions due to same reason, less than 2 technically bidder, then in the context e-auction, the same mind, the single technically qualified bidder, if any, shall be
This
allowed.
is your first occasion.
Yes, Miller. And next B also, where the total number of technically qualified bidder is more than 1, the auction process shall be proceeded to the second round, which is held so. More than 1, Miller. Here, Miller, Lordship will kindly have a look at speaking order, Miller.
And this is the first time.
Yes, speaking order, kindly look at page 166. Point number 5.
Yes.
On 26/9, the signed copies of submitted by along with joint DFO and also keep it seal cover in this office by third bidder Ranadev Soga, that is the private respondent. However, fourth bidder so and so submit the document in spite of repeated notice so and so. Meanwhile, fourth bidder had withdrawn the earnest money demand so and so. Thus, from the above list, it is seen that 10 bidder were involved in Dikrong and mining, sand and gravel mining context.
No. Tell me, there is one technical bid and one price bid.
Price bid.
So once you are technically qualified,
then is
the
comes
price
at
bid,
second.
then the only consideration is the price bid.
Price bid.
So can the question of eligibility be looked into if you are technically qualified thereafter?
Right.
Once you are held to be technically qualified,
right,
then the question of you go to the second
round.
So therefore, you will go to the second round. Now, what is there in the second round?
Second round, Milord.
Let us see what is there in the second round.
At page 55, Milord. 56, Milord.
Yeah.
C.
Only those bidders who are found to be eligible in accordance with the terms and all eligibility in the above clause valid documents that stated above into equal or greater than the shall be considered for the second round. Now let us see the e-auction second round. Somewhere it will be there, the second round, the 2-bit system.
Lordship, at page 55, Milord.
I'm sorry, Mr. Lordship, kindly see 56D. 56D, your Lordship is reading 56. See 56D.
56D.
Yes, your Lordship has read 56C. D kindly see. The highest initial price bid offers a technical qualified list shall be floor price. Normally, if there are less than 2 technically qualified bidders, then the auction process shall be annulled. And such technically qualified, if any, won't get a chance to proceed to second round of e-auction. However, if such e-auction annulled on 2 considerations due to the same reasons, less than 2 technical, then in the next.
No, it's okay.
Now,
once you are as per that order, it has been held that the petitioner, him, and you have been held to be technically qualified.
and another person, I kindly see 154 page, 154. In the second stage, how many qualified? 154.
154. 2.
Therefore, 2 has been technically 154, 153. So therefore, in view of the above, is directive to continue further with the NIT. E-auction process, second stage of bidding, with qualified bidder, namely there are 2.
Who is Ganesh Talwar?
Ganesh Talwar, one of the person, one of the bidder, and myself, Rana Desai.
No, we are not concerned. This thing has already been set aside. We are concerned with this one. 165.
Yes.
165 categorically says that he is technically qualified.
Not below, technically, only technical qualification is the,
No. Kindly come to number 6.
as bid of the evaluation committee dated so and so, bid of 3 bidders, Ranadev, Sogia, Ganesh and Tonkeshwar Dole were technically qualified, but they, Ganesh and Tonkeshwar Dole, we don't their earnest money. Only remain in the free, the respondent 5 million. Another state.
When did they withdraw the earnest money deposit?
What's it? That has to be.
Yes. When did they withdraw the earnest money deposit?
Till that period, court sees in the matter, during pendency, they cannot.
But this technical qualification were there 3.
I'm gonna pay query. I go to withdraw question.
Yes, Mr. Gogoi.
And it's point number 5, my lords, that page 166. On 26/9. First, my lord, the paragraph 4, point number 4, my lord, the honorable court was session of the matter, my lords. So on 5 and in para 5, 26/9/22, they were submitted, my lord, this Ganesh Kalwar failed to submit his bid document in spite of showing money, and he withdraws his earnest money, my lord. 5/12/22.
That means before passing this speaking order.
No. However, Tolokeshwar Dole and Ganesh Kalwar failed to submit. However, court bidder Ganesh Kalwar failed to submit his bid in spite of repeated notice. That means he was not technically qualified. He did not submit his bid. Finally come to 5.
My lord.
However, the 4th bidder, that is Ganesh Kalwar, failed to
it seems
submit
so.
his bid in spite of repeated notice. Now, if he has failed to submit his bid, he cannot be considered to be technically qualified. So why in 6 it has been mentioned that he was technically qualified?
My lords, paragraph 4, my lord. Paragraph 4, my lord, say the honorable court, my lord, had ordered, directed a rehearing, my lord. Pursuant to that, my lord, hard copies were asked for. He had submitted his bid online, this Ganesh Kalwar. My lord, due to court's intervention, my lord, a rehearing was given wherein hard copies were called for all the bidders. So since there was a court order, my lord, he was asked to provide hard copies. And due to his failure, that para 5 indicates that, my lord.
But here at para 6 you say, but if you have not submitted the hard copies earlier, he was was it required for him to submit the hard copies earlier?
Well, no.
Then how did you hold him to be technically qualified without the hard copies?
At the first round, my lord, everything was online, everything was good, all well, my lord. Then dispute arose. Then they came to this court. Court said, give hearing hard copy.
That is a different thing.
My lord.
As per the terms and conditions, is it required to give the hard copies?
Normally, it's not, my lord.
No, not normally. We are concerned with as per the terms and conditions, is it required to give the hard copies?
No, my lord. Everything has to go online.
So under such circumstances, you could not have disqualified that. Now, when did he withdraw the earnest money deposit?
It's written on, my lord, 5/12/22. 5/12/22.
Where is it mentioned? That is only, meanwhile, the 4th bidder. 4th bidder is Rana Shankar Sahu. He has withdrawn the earnest money deposit.
4th bidder, my lord, Ganesh Kalwar, there's a amount, my lord, 29,40,000.
4th bidder, meanwhile, the 4th bidder, you see number 1 to 4. Now, if you see, thus from the above list, it is seen that 10 bidders were involved in Dikrong contract, out of which 7 bidders were not interested.
My lord.
And as they had withdrawn the earnest money deposit. And this includes Rana Shankar Sahu
My lord.
and this Tokeswar Doloi.
Dole, yes.
Okay.
My lord.
Now, thereupon you see, thus as per the report, the bids of the 3 bidders, Rana Dev, Soikia, Ganesh Sarwa, and Ria were technically qualified. How do you make them technically qualified then?
Well, kind of see page 55. Your lordship is putting a query whether hard copy is required or not. See 55, 8. Electronic, it has to be given, but due to intervention of the court, physical document, lordship will kindly see 8 e-auction process. After that, A first on e-auction, then 2, Roman 2, an initial price offer which will be equal to a greater reserve price. Technical by initial price offer must be submitted electronically as per schedule 2. Technical details regarding electronic auction available on the website spelling a technical bids are deemed to be not received. Duly execute original physical copy. Technical may be demanded by the authorized address stated in clause 13 for anything, anytime, bidding process. In case of difference between documents submitted electronically and original documents submitted physically, the original document submitted physically shall prevail. So when the
Understood.
matter was
No,
moved,
all these things are understood, but the thing is, may be demanded.
yes, no.
So
when the
it is not required that they have to, but when demanded, you have to produce.
Correct. Milo, when we came before the court, this was the problem. Because they said some dispute cropped up, then said, no, you will get an opportunity for physical verification of the document. That was the order of the court. So the court said, why others should be left out? All should be called and asked for physical verification of the document. So everyone was called for physical verification of it. After going through all verification, physical verification of document, this is a speaking order which has been passed. Technically and financially.
No, understood. But is it the case that a physical verification of documents, if he have not submitted, he would be technically disqualified? Because that is a very important thing. In view of the fact, the other 2 persons, there were 3 persons who were technically qualified. 2 left, of which 1 did not, both of them did not submit the earnest money deposit. Therefore, you see at page 166, out of 10 bidders, of which 7 bidders were not interested as they had withdrawn the earnest money deposit, namely, of which kindly see number 4, Rana Dev Sahu. This is the same as Rana Dev Soikia?
No, Sahu.
Sahu is different.
This is Rana Shankar Sahu, Rana Dev Soikia.
Okay, now, of which this person kindly see Tokeswar Doloi, and the other is Ganesh Kalwar, number 1 and number 7. They have withdrawn.
I will see that page 6, the bid evaluation committee report date.
No.
Report date is of
page 166.
Yes, madam, 166. Lordship will see paragraph 6. The technical evaluation committee, which holds them to be technically qualified, is of 6/7/21. The petitioners approach to court. Court gives a direction in 29/22.
So when did they withdraw? They withdraw later on.
They withdraw, my lord, perhaps at
no, 1 person withdrew on 5/12/2022.
My lord.
I have a note, I don't know whether correct or not. At the time of when the matter was moved, when some records were produced, I have a note, I don't know whether it's correct. This Tokeswar Doloi withdrew in the month of July 2022. This I have a note, I don't know whether that was some produced, so I just noted down. One they have mentioned it, but this is July 2022. This is your lordship is putting.
Now, whether these 3 persons went to the second stage
Technically, they went, my lords.
No, no, no. Whether you have gone to the second stage as of now.
It has been gone to, my lords.
When?
They have gone and a letter of intent and was issued, my lords, on a statement.
Where have you gone to the second stage? When did you go for the second stage?
That has to be.
Lordship, kindly have a look at 169 minutes. Last order minute.
I've seen it.
Order. In the light of above observation and finding, after careful examination of all record and document is found that physical document submitted by Ragia KU Enterprise and Otis Burra were
Disqualified in the bid of
and hence
so submitted on examination was found to be qualified.
qualified. Only one.
Now, did you go into the second stage?
Second was gone into, my lord, but that has been.
When?
That has to be. What to check on?
We'll take it up at tomorrow, 2 o'clock.
Very well.
It's a matter tomorrow at 2 o'clock.
I know.
Letter of intent has been issued. That's why they have gone to second stage. Your lordship is asking which is the date they have gone to second stage. Letter of intent, after going to second stage, they have issued letter of intent, which has been put to the court said that yes, you can go with all pending here, but no final no, intent will be issued. No final. So at this stage, it has come to standstill.
No, therefore, when did you go to the second stage? That is the important aspect. No?
I'll answer that question tomorrow.
Lordship,
Just
that's
get it
why
out
that,
there. Because the moment, if you have gone to the second stage earlier,
yes,
at the time when these other two were here, then the question of his contention pertaining to the two persons, there were only one person could not survive.
My lords.
That is my
My lords,
focus.
yes.
Because they withdrew later on. So they became technically disqualified. Now, whether at that point, who were the persons who were available at that point of time when you went to the second stage?
Tomorrow at 2.
Or if the entire proceeding, was any proceedings challenged at the quashed by the
Lordship. Lordship, earlier rejection was set aside and direction is to fresh consideration.
Then,
Then, Lordship, any means if second
the
stage is
rejection of the technical bid was set aside.
Lordship,
And then for fresh
fresh
consideration.
consideration.
That has a background.
No,
my
okay.
lords.
Fresh
Then-
consideration. That means, my lord, any
No, then I understand. I'll infer. Don't
Lordship,
worry.
Lord,
Then what happened the next?
Lordship, if second stage is required to be held, then after
The second
second, my lord.
second
Right.
evaluation. Now,
But
in the
that-
second evaluation, what happened?
Seven is again rejected. Then only runner-up should come. That means respondent 5 was decided to be
When was it rejected?
rejected on 8/2/2023. my lord.
8/2/2000. No, that is the final impugn order.
Yes, my lord.
I'm not on that. I'm therefore saying.
First rejection, my lord.
So at that point, because you see, these people went out sometime in the year 2022.
Lordship.
When these people went out in the year 2022, whether the first stage was interfered at that point of time.
Yes, my lord. There is an interim order, my lord. Interim order. Without proceed to the second stage. my lord.
Not to proceed to the
Not to
second
second
stage.
stage. Yes.
And then also they proceed.
Yes.
No. Condition precedent was that, my lord, they came before this court, they disputed that I have submitted these documents.
No,
He
no.
said we don't find
Take
it.
it tomorrow.
It's not technical.
Technically,
They have not gone to second stage. The court said, when they came to the court, they said, how can we disqualify technically? Because this is what they left on the government side. Court said, no, you can't do it. Then it was sent back. Again, revisit technical. On technical point, it was revisited. Then when you went to the second stage, technically, they were also called for. Again,
No, therefore I'm asking. As of now, have you gone to the second stage?
yes, they have gone to
Yes,
second
yes,
stage. They have gone to second stage after participation. Third round of litigation, my lord. Second stage has gone. and technically bid they were rejected.
No,
Afterwards.
understood, technical bid.
No, they have gone, later
But after the rejection of the technical bid in the second round,
Second,
after the
I
first round.
understand. Second stage, they have gone. If they have gone to second stage, that's why letter of intent is being issued to us.
Therefore, that is why I'm saying that if the letter of intent has been issued, that means they have gone to the second stage.
Correct, right.
But the question is whether there was any interference by this court of the first stage.
No.
And without adhering to that, they went to the second stage.
That's, I think respectfully
That is the
submission is
okay.
Lordship,
2 o'clock.
Lordship, I'll satisfy tomorrow minute.
Always, madam.
Hello.
And we are, this is unstable, we are just concerned, we'll just subject us to whatever court gives, madam, we'll settle anybody.
We will see what you do later on, but first of all, let us see what is it. Anyway, any urgent matters? I'm rising to their lead because some meeting. No urgent matter.